Is Mr. Suarez coming back?
Yes, you just.
We'll wait for him to return. All right, good morning, everybody. I'm going to call to order the Town of Loxahatchee Groves Code Enforcement hearing. Today is December 1st. It's 9:04 by Verizon's time, so we can get started. My name is Amity Barnard. I'm the Special Magistrate for this morning's hearing. First thing I'm going to do is swear everybody in who's here to testify on any items on today's agenda. So if you're here for a code enforcement matter and you plan to testify, if you could stand if you're able and raise your right hands for me. And let me ask the town, is there anybody on the computer today appearing?
There could be one person.
Are they on there now?
No, not yet.
Okay, very good. So can you let me know when they pop on?
Mhm.
Okay. If you all are, so all the rest of you are not here for code? You're an attorney, so no attorneys, just people who are here for code. Raise your right hands for me. Do you all swear affirm to tell the truth, the whole truth, and nothing but the truth? Thank you. You may be seated. So a bit about process. It looks like, with the exception of the final case, everything on the agenda is a violation hearing. So when you hear your case called, the town staff is sitting here at the table in front of me. You're going to come to the podium here to my right. The town will present its case first. They will show me any evidence that they want to enter into the record, call any witnesses that they intend to call, give me any verbal testimony that they would like me to hear. Once the town is finished with its presentation, you will be at that podium over there. You will be able to show me any documents you have with you, give me any verbal testimony that you'd like me to hear, cross-examine any witnesses that the town has called. And at the end of hearing both sides, I will make a final ruling and you'll receive a copy of an order that reflects that ruling in the mail after the hearing. So with that, keep in mind that all of your testimony this morning is given under oath, and I'll turn it to the town to call its first case.
Good morning. First case is Thomas and Sheila Wozniak, address 14090 North Road, PCN number 414143170142900020, case number CE 2547, code sections 30-7 imminent public health threat, code of ordinance 30-14 nuisances, ULDC 70-015 maintenance of swales and coverts.
Morning, Your Honor. For the record, Code Compliance Officer John Suarez presenting KCE 2547 in reference to the property located at 14090 North Road. The notice of hearing, notice of violation was posted at the property on October 28th, 2025. Same copy was mailed certified to the property owner on file from the Palm Beach property appraiser on October 28th, 2025, and it's also here posted at Town Hall. The violations that exist are section 70-015, swales and culvert maintenance, 30-1, purpose and intent, endangering public health, 30-7, imminent public health threat. It's an issue with a culvert that runs under a public dirt road. The culvert's in disrepair. For the record, the Public Works Superintendent Craig Lauer and Lead Code Officer Deanna Thomas and I met with the town contracted engineer on November 7, 2025, and discussed the violation and ways to comply. We'd like to let Craig speak at this moment. He's a subject matter expert.
All right, go ahead. Give me your name, sir.
Craig Lauer, Town Loxahatchee Groves Public Works Superintendent.
All right, go ahead.
As of arriving on this pipe that we had seen, the pipe was collapsing the roadway, making it a public safety issue for the town. As I forget the date on the actual pictures that we have of them, they have all the pictures. Everything that the town had, we had to actually go out and add material to it. We dug the pipe up to check the pipe. The homeowner explained that, saying it was from an FP&L line going through it. As we dug it up, the pipe was actually collapsing from rotting from old age. Every time, as far as we kept trying to dig it back, it just kept collapsing. We had to cover it back up because the road was collapsing itself. Give it a month down the road, homeowner tried to pump water through the pipe, collapsed the road completely. We had to come out at, I think it was 9, 10 o'clock at night and rebuild the entire roadway. That the whole road had collapsed.
All right, and I'll see pictures at some point, but
Yeah.
just explain to me, so the culvert is the private property owner's culvert, but it goes under the town's road, is that
Yes, ma'am.
correct?
Correct.
Okay, why is the culvert going under the town's road?
It's the drainage for their property that drains out into the canal, so they can actually have drainage.
And it's a permitted culvert?
Probably not from back in the day,
Okay,
because I mean, the pipe was probably installed 40 years ago, I would guess, or 30 years.
all right. All right, anything further, Mr. Lauer?
No, ma'am.
Mr. Suarez, were you going to continue or were you finished?
I'd like to see if there's a representative. I mean, we are requesting, well, the town is requesting 10 days to submit an application.
Application for
Right
what?
away, a right away permit
Okay,
and obtain all necessary permits. And then upon that, upon issuance or upon submittal, we're looking for 14 days after the submittal for issuance.
all right. Let me see your case file if I may. And you're here for this case, ma'am? Okay, can you come to the podium? Thank you. All right, your name, ma'am? Is that microphone on? Let's make sure that's, so I can hear you.
Thank you. Melissa Klusky here for the homeowners, Thomas is here and his son, Thomas is also here to give evidence today.
All right, what was your last name?
Klusky, Chluski. First name Melissa.
Okay, let me look through these documents for a moment and then I'll have the code officer show them to you.
Madam, you have your,
He just joined.
Who is that?
I-
Okay. If you can hear me from the internet, the hearing has started, but I think, is that you, Miss Walpole Edwards?
Yes, good morning, Katie Edwards.
Okay.
Local.
Good morning. I think your last case on the agenda, so we've started, but we're not quite to your case, so I'll come back to you when your case is called.
Thank you.
All right, so Mr. Suarez, can you, before I show the respondent this evidentiary case file, what are these photographs? What am I looking at here?
So you're looking at the road where initially Craig went out, but you'll see the culvert in the road, it drains from his ditch into the canal, the drainage canal. So you're looking at the dirt coming out from the canal. You should be looking at the culvert. I did not get pictures of when the road collapsed, but Craig was on scene when it collapsed, when I believe the property owner tried to repair it himself.
So this photograph that I'm looking at from October 28th, which is the date you sent your notice, what is this?
May I approach, Your Honor? What?
Let me ask him and then I'll get your side.
So that's from the other side of the canal. We're looking at the culvert where all that dirt's coming from. The culvert, the dirt is coming from the culvert and it's just coming out into the canal. On the other side is the property owner's property, but that's a shared culvert under the road.
Madam,
So go ahead, Craig.
that is the roadway material that is washed into the canal. That is all the roadway material that's from the roadway and the canal bank that is washed in.
Okay, and you're telling me that came out of a culvert, this sand that's on both sides of
That's
it?
from the culvert itself, has a hole in it. And every time it rains, the water's just flowing out of the water, out of the culvert, and it's washing out the roadway from underneath.
Okay,
We could print out the ones from the initial, the big washout, and if you wanted to add them into the case or not.
all right, let me have you, Mr. Suarez, show the attorney the case file. Take a look at those, take as much time as you need. I'm gonna ask you if you have any objection to the documents when you're done, so take a look through there. Yeah, go ahead. Yeah, you can turn it off if you don't want to be picked up, or you can point it away, that should be enough.
This is normally where we could go, right? Oh, no. It's intro voting. With a Dennis Purdy is part of the place or something? Mm-hmm. Well, I guess they got a win. So I don't know if what of that is. Well, Katie.
We reviewed it. Ma'am, we've reviewed it. We object to some characterizations that they're using for it. And
So
what
we'll
they're-
get into that. Any
Yes.
objection to the documents themselves?
The permit application, we have not reviewed before in the communications, so we'd like to further time to review what they're requesting and what's being asked so that my clients can come into cure. These documents weren't provided to us. Everything, the photos we weren't received, but we stipulate to them, but the application and the communications with regards to repairing and replacing, we'd like further time to review that.
That's fine. So just as a matter of process, so the only thing that the town is required by law to send you is a notice of violation and a notice of hearing. So it's not typical that you would receive the evidentiary case file before the hearing. Mr. Suarez, can you grab that from her? I typically admit everything just so it's all on the record and we can fight about it and you all can fight about it later, but just so you understand, it's not customary to get everything in advance. That's the purpose of today's hearing. So with that, I'll admit the town's composite exhibit 1 over objection. And I guess let me hear from you. I have some additional questions, but let me hear from you.
We have a packet too that you want to bring this up to.
Sure, so show it to the town first. I don't know if the town's attorney is here. Mr. Suarez, is the town's attorney present at this hearing? Is he intending to be here?
I will.
Initially, Your Honor, we don't think this is a situation where any fines should be levied here today or violations found. My client received 14 days notice only to
Mhm.
cure this situation. It is, let's go back a little bit also. When Mr. Lauer, who I'd like a chance to talk to,
Let me have you hold on. Let me ask, I'm going to recess. Can you please go get the rest of the town staff who was here at the hearing? Mr. Lauer needs to be in the room. He was a witness. Let me ask you just hold, please.
All right, ma'am.
The attorney has some questions, I think, for you, so you need to be here.
Yes, ma'am.
Thank you.
so
Go ahead, ma'am.
it's my client's contention that the city came out, or town came out, excuse me, in May of 2025 and filled where Mr. Lauer pointed to in the depiction. And they put this fill there for some kind of maintenance project and a digging was done. There's FPNL easements going there. So he kind of brazed over that and said he had to dig out there in October for some, there was no notice. When was he digging there? When he said that he was digging, because we have proof and evidence that we'd like to show the court that the town came in, the Water District Management came in and did some maintenance on the canal swell. And they covered the culvert themselves with their fill when they did that.
And when was that?
That was May of 2025.
Okay.
So they did that, and I have some photo evidence in your packet. You can see where the culvert in section 1 is visible here. Page 1 is a little bit blurry. But page 2 or section 1-2.1-3. You can see our culverts there. My client's
And let me
culvert's there.
stop you there. Mr. Kurtz is now in the room. Mr. Kurtz, that's the evidentiary case file that the respondent is wanting me to enter into the record. So if you could review that and let me know if you have any objection before I take a look at it. Thank you. Go ahead, ma'am.
So in May of 2025, so that's what it looked like before in the beginning. You could see the culvert there and a better depiction on page 2.
Mm-hmm.
And then if you flip a couple of page to page section 3, back in May, the city or town, pardon me, town of Blacksburg came in and dug something up there and put fill there. And that was a road project. So, and they covered the culvert. Ever since then, there's been flooding on my client's property since the town covered his culvert. That was proper working. The statement that Mr. Lauer made that there was a hole in the culvert, there's no evidence of that. It was working fine up until this point. My clients repeatedly contacted them to say, hey, this is going to cause some backup when rainy season comes. And rainy season comes and there's a problem. And my clients are on the phone in July calling Mr. Lauer saying, you know, we told you not to do that. Here's a situation you've created here and you've blocked up our culvert and we're, you know, and then they've been trying to deal with it. Rainy season comes and the fill that this town put in that area and covering the culvert begins to slide away because it wasn't impacted correctly or, you know, just natural. But you could tell that this is not a project. This is not culvert. This is not dirt from a culvert. This is a public works digging project where they dug, and then we get into it a little bit further too, but they dug in this area in May and there's exposed power lines there. So my client wasn't digging in the power lines. He was given 14 days to cure this issue. Months later, after immediately contacting the city saying, hey, this is wrong. What's going on here? There was no need to dig up the line on October 28th. That digging didn't occur then. The digging and the repair work that he's referring to happened in May. And it wasn't as a result of a non-functioning culvert. We don't know what that was there. It's probably because the FPL lines created some issues that run parallel there. There is, you know, some clarity issues with what the code enforcement is asking my clients to do after they caused the issue. And, you know, there's no proof that the culvert wasn't working. Otherwise, you know, they're showing pictures from October 28th, and we have the pictures from May showing that, you know, it was a road project and how it looked before. So we have that, and then we have those issues, and then they're trying to say like it was a public health, and, you know, they're glazing over the town code and what they need to do in order to declare an imminent public threat. If that occurred back in May, there's no evidence of that in the court file either. And what's clear is they're traveling under section 30.7, and that should have given my client at least 20 days to get some community, some clarification on what they want to do, and to present their evidence to them and communicate with one another in a nice fashion regarding the cure or the correction required. The town, if the culvert's broken now, it's the town's fault for covering it up as they did in this situation. There's no imminent public threat hasn't been established. The road falling out, my clients were the one calling when they never attempted to fix it themselves. They attempted to cure the violation that they were given. And because if it says repair and replace the culvert, my client can testify that he was told, and that's in our statement, that to get the water moving through that canal. I mean, they were actually really asking my clients to dredge a canal and to, you know, maintain canal walls, not to just repair a culvert, because their culvert they can push it through. When you push the rocks through the culvert, that he's been probably permanent and was there, put in by the city years ago, by the way, Your Honor. My client can hear to testify to that.
Say that again, that the town.
Culvert, but put it in back in it was a permanent culvert.
The culvert was put in by the drainage.
Can you give me your name, sir?
That wasn't second.
Okay, go ahead, sir.
Culvert was put in by the drainage district 1967. My father paid for them to put it in.
So, and it's been in good working repair up until the town.
We're fine till that first picture they show. You can see where the dirt's caving in on that picture. It's already sliding down the bank, and that was the day that they put it up.
That's the May
He's
2025.
saying that it walked it away. I haven't been out there and done anything.
And when you say the date they put it out there, what do you mean? They put
The
Bill?
front picture where that bill
Section 3.
where they dug the culvert up and they buried it because they got into the FPNL power line and pulled it up out of the ground. It's sitting there, you can see it exposed.
So before my clients can fix this, you know, they have to run 811 reports to dig in that area that we know have photographs of exposed power lines. And that is in your documents, section 4, thank you. Section 4, if you see this, there's a red line, that's an exposed power line that when they tried to get into compliance after speaking with, you know, they just stumbled, they realized what happened. You know, they covered the culvert, they dug up lines, no 811 calls had been made and surveys or tickets issued. When they did that work back in May, we have evidence for that, and that's in your packet. Failing to, you know, starting to dig up a property and a culvert without dialing 811 and getting a, you know, working ticket isn't, you know, establishes negligence per se on behalf of the town. You cannot just go digging in easements and ask my client to correct the road work that they initiated with this initial project in May. We've asked for some public records on that. We're still waiting on them. We asked for an extension for this hearing. We were denied. Even though we weren't given the full 20 days as per section 37, which requires specific forms to be set out. There's deficiencies in the notice, sufficient legal deficiencies as well, Your Honor.
Okay.
Or sorry, Madam. You know, section 30-8 requires 20 days. They gave us 13 days to cure. Their own packet shows, you know, a 15-day requirement and a 10-day requirement for permitting, is what I've noticed. They're asking to replace the culvert that they broke when, you know, if it's their culvert, if they did the damage in May and it's unclear what, you know, there's this evidence that he's saying that he dug and, you know, had a dug because it was a hole in it. There's no evidence of a hole. There's only evidence, that, you know, of some issues maintaining the road, and when they maintained the road, they covered the culvert. We've asked for more time. We were extended. This is not a situation where my clients are in open violation. There's no public nuisance been established. They filled the road due to the issues caused by the city, town, pardon. We're just looking for clarity at some point on this too, Your Honor. We would like to communicate with the city a little bit more, town, pardon. We think they're actually using the part of the code to say maintain a culvert free of trash and debris into, you know, maintaining the public road here, after they cause the situation and plugging it up. We also have issue, you know, the city, the nuisance issue, what they're creating should have been decided by the town manager and effectuated by certain forms dictated by code 30-8. That wasn't followed. We've got just a lot of, you know, procedural issues that we have with the notice, you know, denying the extension, denying, you know, giving them only 13 days.
When did you request an extension? And to whom?
What day? You have an email on it. It's in the packet where there's an email. It was, we'll find the time. Okay. I think it's done. It's not on it. We requested by email, client did by email.
Oh, I see it. Okay.
You see it? Hello?
I saw the email from November 3rd there.
You know, and he went in, his son went in person to talk to them, try to work this out. You know, it's, you know, it feels like one hand doesn't know what the other hand is doing on the public works with the code management issue here. We'd also like clarity on how this code violation started. Yeah, who was the code, you know, who called this out? If it was just, you know, how the definition of a imminent public health threat was made. What was the, you know, evidence of that? There are undated photos with respect to the May, I'm sorry, not undated, the photos in October 28th, August, fail to reference their own work, completely shielding it. So we're asking for more time, no violation, and more time to discuss whether this is even my client's responsibility due to their actions in digging without the 8111 report back in May and backfilling it in with the fill that they claim at the hearing just now was a result of dirt from the culvert, which is just kind of impossible. A culvert doesn't flow through a dirt. I mean, dirt doesn't flow through a culvert like that. It's water. And you know, it misstates what drainage does.
Yeah.
It just doesn't make much.
This day,
Okay.
I had to pump.
Stand up there just so the microphone picks you up, sir.
My culvert is still plugged. I have pumped in the last 4 days over 300,000 gallons of water out of my backyard so that I can get to it.
And just so I'm clear, when we're all saying the word culvert, we mean this tiny little pipe. It's a how,
That's inside my culvert. The drainage district put that a couple of years ago.
but you're
put that
talking,
in.
this is what you're calling a culvert. Is that correct, sir? No. So what is this pipe?
Yeah, that's-
That is the pipe that they stuck inside my culvert.
Who's
and
they?
Buried it. This is the drainage district prior to
Okay.
it becoming part of the town.
All right, go back just so the microphone picks you up so I hear you. So how, does anybody know how big the culvert is that's under the road?
15
Okay. And this pipe is not the culvert. This is the pipe that goes into the culvert?
They stuck in it and then buried it. It's
Okay.
been that way for 10, 15 years.
Okay.
I do like to stipulate that the definition of culvert is nowhere contained in the violation notice, whether or not they're talking about a pipe or the surrounding area. The FDOT has several definitions of culverts, none of which have been cited in the notice violation.
Okay. And let me, while I have you have the floor, do you have any cross-examination of any of the town's witnesses? Do you have questions? You don't have to. I just want to give you time to
I just asked
Do
you
that
this
if you-
lower, are you saying, when you dug, the time period that we were first saying, when you discovered that you were digging because the culvert had a hole in it, what evidence do you have that they're at that, and what time did that occur?
I spoke to your client in person at his front gate. He had told me that there was a hole in the pipe himself. I told him that I was gonna go down there. I looked for it. I saw the power lines down there. We went down there. We sat there and our hands to remove what dirt was in there so we could see the pipe. And that's when we noticed the pipe was completely collapsing. I spoke to your client in person at his gate.
What date was that?
This was prior to those pictures. I spoke to him in person, ma'am.
But when did but back in May, did you you covered the culvert? That's not the same time when the culvert was filled.
No,
But you did cover the culvert back in. May.
I had to because the road was collapsing.
When you covered is there a statement, any statement of a public imminent emergency, any notice, any field tickets
We
for that?
had to cover it back up or we were going to shut the road down completely.
Was there any prior notification at that point for curing to my client?
No, it was prior to me speaking to him, asking him, hey, can we want to look at the culvert, it's collapsing the roadway, and that we want to inspect the pipe. I removed the dirt that was in front of the hole so I can look through the pipe, and I couldn't see through the pipe because it was collapsed. And it was rusted out from the inside out.
But it was collapsed, but that was after you put the dirt on it in May.
That was before I put dirt on it. Because it was collapsing.
Well, I'd like to
Madam.
reserve on that and talk to and have my clients testify that whether, this conversation occurred.
Yeah.
This was after the violation, you're saying?
That was before the violation. I spoke to him in person at his gate.
Which Mr. Wozniak did you see?
The gentleman right there standing. I spoke to him at his gate, and then his son called me on a Saturday morning after that.
After the May work.
Correct. His son,
Position, but they've been communicating with Mr. Lower because of the May work but there was no need for that work at that time, what I mean, saying this conversation occurred post the May work. So just want to clarify that.
because we were notifying him that the road was collapsing.
All right, so
All right, I want to
Go ahead.
elaborate on that a little bit.
go ahead.
Me and him spoke.
Mhm.
He wanted to replace the culvert. I didn't want him replacing the culvert because I don't trust the way they do things. I've seen how they do things. And they're trying to claim my property out there, so I'm not letting them touch the culvert. I'll put it in if I need to. He wanted to take, he said he could take and dig it out and put a sleeve over it to make it extend out further into the canal. And I told him, because they have over the years kept pushing the road further and further out so that they have property there. They don't own but about 2 foot of property, the rest of it mine. And I told him, if you dig down in there, you're gonna have to dig back past the edge of the pavement to be able to get to where, because the pipe has a long taper to it. It's cut off. It's got a long taper.
Okay.
It's about that long. I told them they would have to dig back into up underneath the road because that's how far they pushed the road over into the canal. And I told him if he did that, everything was going to collapse in. Because you're going to be up under the road before you get to good piping then. So, a round pipe instead of being a tapered pipe. And that's when he went ahead and did it anyway. I told him that power line run down that canal bank. He told me and my son both that we were idiots. The power line run down my fence line. I said, no, it does not.
No, we know
Because
exactly. where
I
it goes.
opted out of letting FPNL come across my property with that thing. That's why the power line is out on the dip.
Okay.
Everybody else has moved their utilities. The water line runs on the other side, the north side of the canal. FPNL is right down the canal bank. The town's the only ones that keeps trying to get into mine.
So
But
let's,
this was all done, I was in May when all this was done, I was working in Indiana. I was not here.
okay.
So he didn't talk to me then. But we did talk the year before. And the part where they're saying that the road is caving in because the water running through it. And I've never told him there was a hole in the culvert. When the directional boring company come through for the FPNL to put the underground power in, they dug a hole in the canal bank to level their machine out. And then they dug down through there. Well, that hole has been there for 3 years. They never filled it back in. It was only this deep and it was about 7 foot long and about that wide.
Okay.
And someone drove off in it. That's why I got pictures of it in there. It shows where the bank has been pulled away. They drove off in it with a trailer and drug it. That's why the dirt and the grass and everything, that's why I took pictures of it. I went out there that morning and seen it. It wasn't my culvert. My culvert was working. And like I say, my culvert is still plugged to this moment. There's no way water is washing out in there. I did have it open for a brief moment. And the water on my side was 5 foot higher than the canal is. So when it did finally open up, it rushed through there and that's when it washed out all the dirt that they had already disturbed.
Okay.
Ma'am,
Let me ask them if they're finished and I'll come back to you.
yes, ma'am.
Just like to point out a couple of things.
Go
The
ahead.
town of Waxahachie Groves has a program for replacing and repairing culverts that just so happened to occur right in May 8th of 2025, right around this time this work was happening. That they're now saying that my clients are responsible for in some fashion.
Mhm.
But they didn't put notice that their work was going to be on their road. There's some other roads here. This is not in your packet.
Do you want that? Yeah, show it to Mr. Kurtz in the purple shirt there. Thank you.
Yeah. Do you want me to speak to?
Let her finish and then I'll come to you, sir.
So, yeah, so they did not sign up for this. They weren't provided notice of this work in May, and it's clear that it's a town road. It's not repairing or gently, keeping care of the culvert. It's, repairing a road, digging up power lines, replacing, digging into the canal bed to get what they're asking them to do. It's almost, it's a public works project that should be done out there with this, it's not just simply putting a culvert in.
Okay.
And they definitely need more time, and it's not a violation, Your Honor, at the very least. I give a moment to respond if you're.
I'll give you a moment at the for concluding remarks at the end, but yeah, go ahead. Go ahead, Mr. Wozniak.
I would like to know how this all come about for the violation. Because they told me that when we called up and tried to find out that we can't get any information from the town. Why was this the violation sent?
So
Because they're saying that I have to unplug the culvert. I didn't bury it.
I'll ask the
Found it.
town to respond. Was this town initiated code case or was this complaint driven?
It was through Craig Lauer we opened the case.
Okay.
Covering his ass for getting into the power lines.
Keep it professional, sir, please. All right, Mr. Kurtz, let me go to you. Any objection to the respondent's exhibits being entered into the record?
Well, as I understand.
As I understand what's contained herein is there is a notice of violation and a notice of hearing that was supplied to them by the town. There is a homeowner's declaration of facts in response to a notice of violation. It is not sworn to, but it is essentially their statement.
It is sworn, they're declared, it's under penalty of perjury, and it's a declaration is sworn to. And if there's any deficiency there, we'll state it.
And So they're available for cross-examination. The two folks that Thomas N. Wozniak and Sheila M. Wozniak, they both signed and they're both available for cross-examination. Is that correct?
Just Mr. Webb.
Just Mr. Wozniak, okay. And then they've got statement of law and argument. They have a number of emails, it looks like. And then they have supplied packages of photographs. Is that correct?
Yes, and then
And-
so the depictions in the photographs with typing to identify the photos attached to that are blown up copies so that they could be more legible. if needed.
Okay, and all of these pictures were taken by your clients and they would be subject to examination if we want to go that route. All right, just understanding what's there. I do not have objection to that coming into the record. Reserve the right to examine them with respect to it. One of the things that I'm hearing from the respondents council, it sounded to me like they were requesting a continuance, basically.
They submitted a document that suggests that they requested a continuance on November 3rd, which they've indicated to me was denied by the town.
And as I understand it, there's a continuing request for a continuance with respect to this matter. Is that?
Yes,
I do not think that the town has an objection to continuing this matter. If that'll lend clarity to everyone.
we'd like at least 60 days if they're, Your Honor. I don't want to come back and have like little time to go over this. And if we can really work that out, I'd love to talk with Mr. Kurtz if that's possible.
Yeah, so let me just make sure I understand what the parties are asking. Let's make sure the record is clear when we're speaking about a continuance. Are we, is the town amenable to a continuance, just strictly setting this for violation hearing in whatever number of days, or is the town seeking a finding of violation today?
I think we would be okay with a continuance of the hearing itself. My understanding is, and I stand to be corrected by Mr. Lauer, that the pipe is currently blocked, and so it is no longer posing a danger of collapse since that apparently has already occurred. And it is in a stabilized situation at this point in time. Is that correct, Mr. Lauer?
Correct. We have
And so,
pictures of where
uh,
the pipe is completely collapsed and everything.
Yeah, and so the underlying situation is controlled at the moment. And I don't think we have any objection to continuing this hearing for a 30 to a 60-day period.
All right. And Mr. Lauer, are those photos that you are
No, these
intending?
are the ones I was telling I was going to print to bring to you.
Okay, so
Can I
show
just
those,
present 'em?
yes, show them to the respondents council first.
Okay. These photos are on November 6th at 9:30 at night.
Are they marked on the photographs?
Yes, ma'am. I have
Okay, very
timestamped
good.
everything.
So show
so-
them to the respondents council and then we'll ask her if she has any objection and they'll be entered into the case file as part of the town's exhibit.
I'd like to explain them.
Okay, I'll give you a moment to
ma'am.
do that, sure.
You can keep those if you guys need them. Print more. Yep, unless she wants to add them to that.
They need to be added to the
Need
case
to-
file, yeah.
yeah.
So they can get you copies after
Yes,
this hearing,
We can
but
get you copies, correct?
yes, thank you.
How many do you have there? So I'll make sure I print out the correct.
17, yeah.
Yes,
It's
ma'am.
acknowledged there's 17 photos in this packet.
Correct, thank you.
So we have-
Yes, ma'am, please. Any objection to these photos being added?
No.
All right, so with that, let's do the easy part. I'm gonna add to the town's evidentiary case file, which is composite exhibit 1, these additional 17 photographs, which appear all to be dated November 6th. (2025). And I'll ask the town to, at some point after this hearing, get these stuck into the case file so they don't disappear between now and the next hearing date.
Yes, Your Honor.
But I'll add those, and then while I have the floor again, I will admit without objection, respondents composite exhibit R2. I'm gonna mark that, and I would ask the town to leave this in this case file so that if to the extent this comes back to me on whatever hearing date that is, that all of this comes back with it. And Mr. Lauer, you wanted to provide some additional testimony on those photographs, is that correct?
Yes, ma'am. As the photos you see in front of you, we received a phone call at 8:30 at night from Palm Beach County EOC. They received a phone call from the Wozniak property saying that they were pumping underneath the roadway to pump through the pipe and they blew the roadway out. So the first picture that was presented there is a 15-foot hole blowout underneath the roadway. As we responded, we came to the site at 9:30 at night, brought out material, looked down inside and seen that we were going to either close the complete road down for the night or we had to repair it on the spot.
Okay.
So everything you see there happened that day on November 6th.
All right, so given, I appreciate that additional testimony. I expect I'll hear more of that at the next hearing if the matter proceeds then. So 60 days, as I look at my calendar, would put this on the February 2nd. That's the Monday hearing. Is that amenable to the town?
Yes.
My clients are you'll be out of town? He's out of town and he works 6 months out of, but can he, work on getting your son authorized? So would his son be authorized to testify in his absence or can he appear by Zoom?
You would have an objection to him appearing by saying, I travel for work.
That's fine. So the only thing I would ask, just for council's knowledge, is appearance by Zoom is a little bit difficult in terms of showing evidence back and forth, right? So I'm going to ask you to stipulate, if you're going to be here at that hearing, that's great. So you can see any physical documents that need to be presented and that I need to see. But that's the only risk with appearing by Zoom. But if the town's okay with it, I'm fine with it.
Okay. Yes, Your Honor. Yes, ma'am.
Okay, great. And you're otherwise okay, ma'am, yourself on the 2nd?
Address something that Mr. Lowry just said on the calling or the sheriff's department calling.
Go ahead.
I called him at 7 o'clock that night and told him that the road had caved in. I didn't pump water through the pipe. I shoved another pipe through it, and when it opened up, the 5 foot of water on this side washed out that
Okay.
side.
Okay.
He complained because I called him at 7 o'clock at night. He says, "Are you really calling me at 7 o'clock at night for this?" I said, "Yeah, I don't want someone driving off in the canal."
All right, I
And he didn't
appreciate
show up
that.
for 2 hours, so we called the
Well-
sheriff's department and had them come and shut the road down or stay out there until someone got there to fix it.
Not there.
And then, like you said, about 9:45, they showed up.
Okay.
But
All right.
that wasn't washed out like that.
Well,
They
I
dug
think- I think given-
asphalt up with the backhoe. Can you see?
I
that?
hear what you're saying, but sir, I would caution you that the town is amenable to continuing this. It may be in everybody's best interest to have a discussion outside of this process. So I just want to make sure that's where I'm headed. If you want to continue, we can do that, but I think should be some additional conversations between the parties. You're good on the 2nd, ma'am,
I
of
believe-
February?
I'm sorry, my can't get it. Yes, I'll be here. I'll be.
All right. So with that, all I need to do is make a finding of service for today's hearing. I've entered both sides evidentiary case files. Again, I'll ask the town, bring back this full case file on February 2nd to the extent there is a hearing. But for the record, in case CE 25-47, I will, having entered the town's composite exhibit and the respondent's composite exhibit, I'll find that the town had good service for today's hearing via an affidavit of service as well as USPS delivery confirmation on the certified mail. So with that, I will strictly reset this for violation hearing on February 2nd, 2026 at 9 a.m. And we will deal with the merits at that time.
Thank you.
Thank you.
Written notice, Your Honor.
You'll get an order granting the continuance that I'll sign this afternoon, and you'll get that via certified mail with the February 2nd hearing date.
Okay. I believe I have my email on there for service. Well, it's
If you leave a card with the town, they typically will give you additional notice, but the formal notice, you're here, so you have actual service on that, but you'll get the certified mail as well. But if you leave a card, typically they're happy to email you.
Next case.
Next case, thank you.
PBP Investment LLC, address 392 F Road, 4141 431701 905005, case number CE 2540, code section ULDC 20-0110 B2, general provisions fences.
Your Honor, for the record, Code Compliance Officer John Suarez presenting KCE 2540 in reference to the property located at 392 F Road. The notice of hearing, notice of violation was posted at the property at 392 F Road on October 16th, 2025. Copy was mailed via certified mail on the same day, October 16th, 2025, and a copy was posted at Town Hall. This is a vacant land on 4.98 acres. There is a fence that surrounds the property. A section of the fence is in disrepair next to F Road and has fallen over. We have not made contact with the property owner. The property did have a for sale sign at the time we posted the property. I called the realtor at the time and left a message. I did not receive a call back. And for the record, Your Honor, the same fence, because it surrounds a pretty large property. A case was opened back in August 1st, 2025 for another section that had fallen, and they repaired it within 14 days, but no contact was made. So the fence is falling into disrepair in different sections because of wood rot. At this time, we are requesting that the property owner repair or remove the fence within 14 days by December 15, 2025, or we request a daily fine of $150 a day that the violation continues to exist. Additionally, it is recommended that the administration costs incurred in the amount of $234.05 be assessed in order to be paid to the town of Loxahatchee Groves, and I can submit the full case file for evidence.
Is the respondent present for this case?
No.
All right, for the record, the respondent is not present in case 2540. Thank you. And the prior case you referenced, did that make it to hearing or no? Okay, so there's no violation, no fine running.
No.
So then the section you cited, are there animals behind the fence?
No, there are no animals at the vacant lot. But it is a wooden fence meant to keep the animals.
Is the fence required to be there?
It's not required, but it is an existing fence.
So what's compliance? Remove the,
Blanks, remove or repair the section of fence. Right now it's laying along F Road. Maybe a 20 to 30 foot section.
so they could just pick up those boards. There's no requirement that there be a continuous fence unless there's animals. Is that accurate?
Would be accurate.
Okay. I guess my issue is the code section you've cited. It says animals shall be kept within a fence to prevent the animals from accessing streets or adjacent properties. It shall be the responsibility of each animal owner to ensure that the fence is maintained in a state of good repair and that the animal is confined to the property. If there are no animals on the property, how is this code section applicable?
Ma'am, at times there was horses on this property. There's not horses on it right now.
Were there animals at the time the violation
No,
was written?
there's not right now, but there has been animals on this property. That's what only thing we're concerned of. If they do put them back on, we don't want them just coming straight into the roadway.
How recently have there been animals there?
They come in seasonal with the horses.
Okay. So in the future, I would cite, if you were gonna use this section, I would cite some other section of the town code that applies more generally to fences for cases like this in the future. If the testimony is that there are animals that have been recently on this property, I'll find this violation, but in the future, cite another more general provision that deals with just fences. And then you were asking for compliance by December 15th, but you've had no communication with the respondent. Do you typically post the orders that I sign to the property?
Mhm.
I'll give you the December 15th as long as you post the order to the property, just to make sure that they get it, because certified mail takes a week to get. So as long as you're doing that, that's fine. Anything further in this case?
Nothing further, Your Honor.
All right, in case 25-40, I'll enter the town's evidentiary case file as composite exhibit 1 without objection. I'll find based on the notice documents in the case file, which include both an affidavit of service and USPS delivery confirmation on the certified mail that the town had good service for today's hearing. I'll find based on the testimony of both Mr. Suarez and Mr. Lauer that the respondent's in violation of section 20-010B2. And I'll require a respondent to comply with that code section on or before December 15th, or $150 per day fine will be assessed. In the event of non-compliance, I'll set this matter for fine assessment hearing on January 5th, 2026. And because I found respondent in violation, I will assess the town's administrative costs for today's hearing in the amount of $234.05 payable within 30 days. All right, next one.
Next case, Safar Irrevocable Trust, 15447 San Diego Drive, 4141-431701-207-0460. Case number 25-42, Code Section ULDC 05040, permits required, Florida Building Code 105.1, building codes required.
Code compliance officer John Clark, presenting case 1525-41 reference to the property located at 15447 San Diego Drive. The notice hearing was posted at 15447 San Diego Drive on October 21st, 2025. A copy of the order finding violation and notice of violation was mailed certified on the same date, October 21st, 2025. And according to the U.S. Postal website, the certified letter was delivered and left with the person at the property's owner's address, based on the property agreement. Violations that exist is there was a carport and garage that was converted into a living quarters without the necessary permits. Now, the town has been working with the property owner for at least September 27, 2024, where they've been in contact with the building official, Jack Thompson. He was assisting them and guiding them to help resolve the violation. Looks like they were trying to get it, but it's been a while, Your Honor. At this time, we are requesting that he obtain a permit within 30 days or incur a daily fine of $250. That was not coming up compliance. Districts recommended that admin costs incurred in the amount of $234.05 be assessed or ordered to be paid to the townwide officials. To submit the case folder as evidence. The property owner is here.
All right, your name, sir?
My name is Zia Shokat.
Spell your first and last name.
ZIA.
Mhm.
First name is SHAUKAT.
And you're the trustee.
Pardon?
What's your relation to the trust?
I'm the realtor for the property.
You're the realtor.
Yeah.
Does the owner know that you're here today?
No. The owner is not here.
No, does he know you're here on his
Yes,
behalf?
yes, yes.
Okay, very good. Very good. So this respondent, let me ask the code officer, this respondent's name is familiar. I know I have signed previous orders. There have been previous cases. Has this issue come to me before? Is there a fine running already on this?
So there's a history, Your Honor. It used to be a single family house, and yes, there's fines running, but not, they divided a parcel. So on this particular PCN number, there is not a fine running. There's a fine running for an old electrical board that was installed without a permit, and this is for the garage parcel that was converted. Used to be a single family with a garage carport. They since then divided the parcel, trying to get the proper permits for.
Does this have a different address now?
Yes.
This has a new address. Okay.
Yes.
Because that's carport sounds awfully familiar to me.
Yeah.
But is it the same? I mean, did I hear about a carport conversion on the prior case? Because I can't issue another order on the same violation. That's what I'm concerned about. So I know it's a new PCN and I know the address has been split, but if it was the same exact violation, if this has been going on for over a year.
Your Honor, what I believe occurred was there was a carport that was built on the property, essentially when it was two combined lots. And it was subsequently converted into a residential structure. That didn't get noticed for a long time. A few years ago, there was violation found with respect to the carport. And the cure was to get permits. That then led to a situation in which there was a question as to whether or not there was a legal subdivision of the property, because you couldn't have two primary residences on one property. Ultimately, so the first case that came forward was the illegal conversion of the carport to a residential structure. The solution was to get a permit. When they came in for a permit, they were denied the permit because of the fact that it would have been a second residential structure on the same lot. Ultimately, that gets resolved with the town agreeing to be bound by a determination, I guess, by Palm Beach County that it constituted two lots. At that point in time, they were able to get the permit. And I do not believe that they have applied for the permit on the carport yet. That's not.
So what was the permit that was issued? What was that permit for?
There hasn't been a permit that was issued. There are now two properties that are adjacent to each other. One of them has a carport on it. Because it is a separate lot, it could be a residential unit. But there is, I believe, an outstanding code violation with regard to the necessity of getting a permit for that carport converting to a residential.
We are coming back to a bang here this morning on Monday.
Yeah. So,
Okay.
and I do not, the solution is either get a permit or knock it down. And you would need a permit for demolition.
But really, this is just a paperwork problem, right? That's what I'm hearing you say. They applied for a permit. The town couldn't issue them a permit because it was a residential. Now they've divided the property. So if he reapplies, he can get the permit.
Could get the
Okay.
owning issue. But for some reason, they have not applied for permits. My understanding.
That's as of today, no permits have been applied for?
None been applied for.
Okay.
There have been promises that they.
Okay. All right, so go ahead, Mr. Shakat, is
Yeah.
that correct? Go ahead.
Okay, we had the property split in May 2024,
Okay,
and after that, excuse me, a lot of things were going on, and we had applied for permit and paid the fee too. I
mhm,
have the receipt right here.
okay,
All the permits, whatever were needed.
okay,
But somehow there was a problem with the septic tank. They wanted a new septic tank. The health department wanted a new septic tank and a new drain line.
okay.
That took a lot of time, and finally it has been, we already paid them. We already paid them and we already submitted the papers online on 24th. All the papers, whatever were required
On the 24th of what?
of November.
November, so last week. Okay.
Would you like a water, sir?
No,
All right, Mr. Suarez, can you show him the case file?
I have no. Yeah.
You want that entered into the record? Can the town keep that?
It was paid long, yeah, I can make a copy. They
Is
have
that
it.
from last week's submittal?
No.
That's the old one,
from
right?
Before,
Okay.
yeah. But after that, once we submitted that, after that, there was a long process of splitting the property.
Mm-hmm.
So that took time.
Took time, yeah,
Yeah.
okay. All right, so Mr. Suarez, if you can get my case, excuse me, the town's case file back so I can see that, and then if,
I need a copy.
all right, and there's no objection to the receipt for the,
No objection.
can you make a copy of this? So he needs to take that back. All right, so sir, you didn't have any objection to this case file being entered?
No, I just need to say that since we already submitted all the papers, we just need maybe 90 days to complete everything. We already paid the permit fees and everything, so we can complete the thing and they can do the re-inspection.
And this is just a standard building permit, is that correct?
Yes. Yes.
Standard for the conversion. Standard fee, yeah.
But that's all this is a building permit. Okay, so, because he's asking for 90 days, and I'm not sure that unless there's something strange going on, why it would take that long.
It should.
It has to put the drain lines, actually the main time will be taken by the health department. They have to put they already applied for the, whatever they're doing, we already have a contract with the septic, company, whatever they are doing. But that's what they're saying, that will take at least 3 months. To complete it.
It sounds like he's talking about, completion of actual work, and what we're requesting at this point.
Thank you, sir.
Is an application for a permit for current work. The application that you showed, which I think the fee dates back to 2022. My understanding is that application has lapsed, because it was either not issued or not pursued.
No, because, okay. Because
And my understanding is there is no current application for a building permit in our system.
Well, I think I heard him say you applied on last Wednesday, is that correct?
yeah.
Electronically?
We had applied, we have submitted all the papers online, and this was delayed because of the split. It took very little.
No, I understand that. I understand that.
We already paid more than $3,000 for this thing. But it was taking time because of the split.
But when you're talking about, I think what I'm trying to understand is when you're talking about drainage lines, what are you talking about with the health department? You're talking about the restroom facilities, like sanitary, septic, sewer connection? Is that?
30 days?
Yeah, you're talking, you
Yeah.
continue to tell me about drainage lines and the health department. What does that have to do with?
Other than drainage lines, if we have maybe, for the septic tank, we need maybe 90 days. For inside, we can maybe 60 days. We can complete the work.
But, and just so you understand, the amount of time that I'm gonna give you is just to get the permit issued, not to complete the work.
Okay.
Once you get the permit issued, you have what you have under state law to do the work
Okay.
and
but-
get the inspections done.
Okay, do we have to pay it again?
That's a
Yes.
question for the town. I don't know.
Yes,
But we already paid one time.
Under the building code, you have 180 days in which to get an inspection done to keep the permit valid. That did not occur, so the permit is deemed no longer valid, so you need to resubmit the actual building permit.
But the thing was under litigation, it was under the split, so that's why we couldn't do the thing. You were not allowing us to do the thing because it was under split. And once that thing is done, now we are ready to do it.
That is by state statute that we must follow.
And that's just so you know, that's not what's before me this morning, right? So all that I can worry about is whether or not you needed a permit and how much time I'm gonna give you to get the permit. The fees that you have to pay, you need to deal with the town outside of this hearing process. That's not, I don't make a determination as it relates to fees. Is the septic system required for the town to sign off on the building permit?
No.
No. Okay.
Ma'am, I just checked with our permitting department. Nothing has been submitted in our system. So if he has a receipt, we would like to see it because nothing has been submitted as of 11/24.
Okay. So do you hear what she's saying? She's saying whoever told you that they applied for the permit, what she's telling you is that the town doesn't have any record of a submittal.
They submitted all these, this thing, all these papers, whatever were required for the permit.
But she's telling you that the town doesn't have any record of that. So
We-
whoever, right, I just want to make sure you understand, whoever told you that they submitted to the town, they did not.
It was a contractor. and he
Okay.
said that they did.
Well, double check with him, because what she's saying is she just went back and checked and they don't have any record in their system. So you need, I'm gonna give you more time today anyways, but don't assume that they have it and they're working on it, because
Okay.
what they're telling you is that they don't have anything.
Okay.
All right.
Record, Your Honor, I did speak with our building official, Mr. Thomas, this morning, and he says, yes, he's been guiding him for over a year now, well over a year. Said he should be able to obtain a permit within 30 days, and the town is being gracious with that.
The last time that our building official, Jack Tomasic, denied the application, there were denials made in July of 2022, then all MEPs were denied in January of 2023. And most recently, when Jack became the building official here, he denied it in September of 2024, and nothing has been done since. According to what the permitting department has informed me.
Okay. All right, anything further, Mr. Chacott?
Hmm.
All right. So I mean, I'm gonna give you 30 days, but you need to get on it. You need to get on it with your contractor. This has been going on for over 3 years now. I understand you had a fight on this, on the lot split. That should not have anything to do with this now. Getting a permit within 30 days should be no problem. But make sure you're diligent with your contractor. I'm confident you can get this done, but if your contractor is telling you he submitted and he didn't, you need to be diligent with him because he may not be telling you the whole story. So I'll give you the 30 days just to make sure you have enough time, but I would encourage you to get on your contractor today
Okay.
and get this done because this has been lingering. I remember these cases from years ago. So this has been going on for a long time. All right, anything further from the town? All right, in case CE 25-42, I'll enter the town's evidentiary case files composite exhibit 1 without objection. I'll enter the respondent's exhibit as R2, which is the sales receipt, without objection by the town. I'll find based on the notice documents in the case file, which include both an affidavit of service and a USPS delivery confirmation that the town had good service for today's hearing. I'll find based on the photographs in the case file, as well as the testimony of the town, that the respondent's in violation of section 05-040 and section 105.1 of the Florida Building Code for the work that was done without the required permits. I'll require the respondent to comply with that code section on or before, let's see. And Mr. Suarez, in the future, if you can give me dates instead of the 30 days so that they can reconcile with the hearing dates, that would be helpful. Thank you, just so the hearing is on. So I'll require the respondent to comply by January 2nd, 2026, or $250 fine will be assessed for each day that the violation continues to exist. If the respondent does not comply by January 2nd, this matter will be set for fine assessment hearing on January 5th, 2026. And because I have found the respondent in violation of listed code sections, I'll assess the town's administrative costs in the amount of $234.05 for today's hearing payable within 30 days. So you get an order that reflects that. You need to have the permit issued before January 2nd, okay?
Thank you.
All right, best of luck to you, sir. Thank you.
Next case, Buckpasser LLC, 14872 Gruber Lane, 4141431701305010, case number 25050004, code section ULDC 175-70, general, ULDC 175-11, permits required, ULDC 175-240, violations.
And I think on the permits, you meant 175-110, is that correct?
Yes.
Thank you.
Going forth, Sir John Smart presents a case 250500004 in reference to the property at 14782 River Lane. Copy of the notice violation notice hearing was mailed certified on November 7th, 2025, as well as posted to the property on the same dates. Also posted at Town Hall, same date, November 7th, 2025. This property was initially cited on May 13th, 2025 for the following violations, section 175-110, 175-170, 175-240. FDA permit required. This all started on December 18th, 2025. I'm sorry, 2024 for Public Works Superintendent Greg Lauer witnessed land clearing on the property outside the scope of the vegetation exemption. He also witnessed the filling of a drainage ditch in the rear of the property. I have been in email contact as well with contact with the property owner. He stated that she was submitting for an FDA permit and she's currently working on it now, but it has not been issued. The town is requesting.
Was that recent? I'm sorry to interrupt you. Was that recent communication?
Yes, it's been ongoing.
Okay, but recently you've talked to,
Recent.
okay,
As recent as last.
okay.
So the town is requesting 30 days for an approved application. And then from that date, 60 days for the approval of the FDA.
I'm not sure I followed that.
I'm sorry, submittal in 30 days. And then in 60 days issuance.
Issuance, okay.
And if it's not issued, $250 a day for all three violations. The town is also requesting administration costs in the amount of $234.05 to be assessed in order to be paid to the town of Watertown. As of right now, I believe she did submit an application. We handed back the reviews, the contract engineer, and now her contractor, Jupiter Civil, is has the reviews at this time, but we have not heard that.
And when did they apply? And when did the town issue comments? Is somebody present for that case? Can you
Yes.
come to the podium?
I just spoke to our permitting technician this morning regarding this case, and it has been at least 90 days since the review, but I don't have the exact date. You can find the exact date though.
Okay. All right, do you have your case file? All right, your names, please.
Bianca Berthold,
Tim DeYoung.
Spell your last name, Bianca, for me.
Berktold.
And your name, sir, was?
Tim DeYoung, DEYOUNG.
And what's your relations to the LLC? You're the owners?
I am, yeah.
You're the owner, okay. All right, let me look at this real quick, and then I'll have him show it to you. So this old notice of violation, Mr. Suarez, did this ever get to a hearing?
It's in.
Okay. So there's no orders, no, nothing?
No.
Do you have newer photos, Mr. Suarez, from when you sent the new notice?
Newer photos of the ditch being filled in with the land.
Yeah. Does it still look like this today?
I have photos if you like.
Okay.
Those photos were taken by Mr. Craig when he was outside.
But in 2024,
Yeah.
right? Okay. All right, well, we can get to that. Mr. Suarez, can you show the respondent the case file, please? Thank you. Thank you. And take a look through that at the end. I think you've heard me say to the other people, I'm gonna ask you if you have any objection to those documents, but take as much time as you need to review.
For the record, this case did open up as a complaint. Because the drainage that was built was affecting the neighbors as well. Because now it affected the drainage of the waters not being not passing through to the proper canal.
Fine for me.
Any objection to that case file being entered?
No.
Okay, you can give it to Mr. Suarez. Thank you. All right, so they're telling me that you need an FDA permit. It sounds like you've been in the process. Go ahead and tell me your side.
Can I go way back, to the beginning, if I may, so this all makes sense?
Sure.
So Gruber, there isn't any canals or drainage for the properties. And so the way this is, and I have a map for you, so it makes maybe a little bit more sense, so you can see if I can show it to you.
Sure, let's go ahead and do that first. Let's get all the documents that you have that you want me to look at. Give them to Mr. Suarez and he'll give them to the town's attorney to look at before I look at them. And then you can kind of walk me through after
Yeah.
after Mr. Kurtz has looked at everything. All right, can I see those and can I also see your case file back, please? Thank you. And can the town keep these papers?
Sure.
These copies? All right, so I'll mark those as composite exhibit R2. And I'll admit both the town's evidentiary case files, composite exhibit 1 without objection and respondents exhibit composite R2 also without objection. Go ahead, ma'am.
So on the aerial map,
Mhm.
wouldn't mind having a look at that?
Yep.
The blue is the property in question.
Mhm.
So now you can see if you count between C and D road, we're the closer to C road, right? And there, what they call is a drainage ditch in the back of the property that is supposed to drain the properties. Now, that did used to happen until our neighbor to the west of us, exactly next to us, she filled out an FDA and did all her due diligence and subsequently filled in her drainage ditch. So what that meant for us is no more draining. But
Okay.
also what's happening is the neighbor to the south that is butting up to my neighbor on the west and me. So we have half and half of her property,
Mhm.
right? That entire property now drains into our property. And when I say flooding us, flooding the house. And so we went, and by the statute, Florida statute, we are allowed to keep the neighbor from flooding us. And the neighbor to our east, Mike, you can see that so-called drainage ditch. It's not, nothing is maintained, nothing is draining. And Mike now has the same issue since, and this is since I had a conversation with Mike when we were flooding. Mike is the neighbor to the east, I'm sorry, to our east. Because we were flooding so badly, and he said, well, this started happening ever since our neighbor to the west has filled in that so-called drainage ditch. And now nothing is, the water's not going anywhere. I drove by on the D road, on D road, and I took a picture. This is this picture here. This is what nothing, it's not draining. So I had to protect our property and keep the neighbor from flooding us by filling in that drainage ditch. Now, I am not draining into any of our neighbors right now. We're containing our water on our property. So we're not draining into the east, the west, nowhere. But we are also now not flooding anymore because the neighbors aren't draining into us. Now, I had called Jeff and presented this very issue.
Jeff who?
Kurt, right here.
Okay, okay.
And had a meeting with him, and I called and I had asked to meet with him because it was my understanding that I don't need, by the Florida statute, I am allowed to keep my neighbor from flooding me. And if I'm not flooding them, I'm allowed to protect myself. And I said to him, I said, I don't think I need an FDA for this. And this is where it gets really hairy for me. Jeff said, he did not say I don't need an FDA, but he did say to me, I will look into this, and especially what happened with the neighbor to the west that eliminated her drainage ditch, and now there is no drainage for us, but we are serving as drainage for our other neighbors, especially the one to the west, because there is no drainage for her. To the south. There's no drainage for her. It just all gushed into us. And because that drainage ditch was not functional anymore, because the neighbor to the west blocked it off, this was the whole problem. And literally our house flooded. So I spoke with Jeff and I said, I don't think I need an FDA for what I did. And he said to me, he will get back to me. This was in February 2025, this year. And instead of getting back to me, they slapped me with a code violation. This, I do not think, this was never, I was never uncompliant. I wasn't not communicating. I was doing the opposite. I was doing everything I thought needed to be done. And I got feedback from Jeff in that meeting I had with him. He said to me, I will look into all of this and get back to you. All he had to do is get back to me, and I would have filled out what needed to be filled out and applied for. And they chose not to do that. And in May, they give me a code violation without any other communication, which would have been so easy. So my question is, why, on top of everything else, is being town resources wasted where it doesn't need to be wasted? And is it just so I'm having to pay fines? This isn't right, in my opinion, because I'm not a non-complying resident. I'm trying to do this right, and I am in communication. So why did I get a code violation in the first place?
So I'll give him an opportunity to respond in a second. Let me ask you a couple of questions. So the pictures that you looked at that are in the town's case file, it's very clear that you did something on your property, right? So what did you do to eliminate the flooding? You raised the elevation of your land? Is that what you did?
No,
Okay,
no,
so,
no.
so
We
what did you
cleared.
do?
So it was all wooded.
Okay.
Right, and so for us to even get any access to that drainage ditch, I mean, I wanted to clear that anyway. I had an ag exemption for the back three acres. So I cleared that, and then we moved the dirt around. There was 2 loads that came in, but I have that in an email, which I did not print out, which I can get to you from the town manager allowing me to bring in 4 loads. We only brought 2. But I did not raise the elevation. I did not bring in a bunch of fill to raise that. I did not do that. And was also my argument, not argument, but my point with Jeff, where I'm like, I just don't think that.
Well, we'll get to that, but let me understand what you did. So somebody from the town told you could bring in 4 loads of fill, is that right?
Yes, the town manager.
Okay, and where did you put the fill? In the
Well, I
drainage
actually
ditch?
use it to, no, I actually use it to, a little bit went in the back, but I use it to fill in holes from the trees and things like that, from clearing, from the roots to make it safe for the horses. But it was literally just us moving the dirt from the clearing that allowed us to eliminate the ditch and keep our neighbor from flooding us.
So that's what you did. You eliminated the ditch. You got rid of the ditch.
Yes.
Along the back of your property. Okay.
Yes, because I could not stop the neighbor from flooding us otherwise. It was right on the fence line, and there was no way for me to stop her from flooding me.
All right, but I guess my curiosity is the photos show much more than just your disturbance of the ditch area. It looks like you disturbed almost 75% of your property. Is that not accurate?
No, I cleared it.
Right, and
Yeah.
there's dirt moved around on it though too. So not just trees down, but you changed the topography of the majority of your
No, I
site.
mean, they took out the trees, and of course with that, with the roots and everything else, it's that the dirt gets.
And all the equipment running around on the property, removing the trees. All they did was grade.
Just make it flat afterward.
Flat.
Make
But you
it flat,
graded
and
it.
for the
Okay.
horses, I
Okay.
mean, just make it flat again, because I can't leave, it looked like the moon after they were done taking the trees, because they literally uprooted the trees, they took the whole tree out, and it leaves a big hole. So yes, that looks messy, of course.
Okay. All right, let me have, Mr. Kurtz, let me have you respond to her statements.
Well, maybe if you're gonna ask me about testimony, I better be sworn in.
Well, you're the town's attorney, so I'll swear you in if you want, but I'm fine.
This goes back to a time frame where a town's attorney.
Okay, then go ahead and get sworn then. Raise your right hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
I did.
Thank you. Go ahead.
My recollection of meeting on this, and I don't have the exact date, was there were a number of folks involved in the meeting at that point in time. There were issues with red removal permit. There was an issue of putting pile and some other things into
I don't mean to interrupt you. Can you give him the microphone just so the recording picks him up, please? Thank you.
So the meeting that took place when I was the project coordinator, it involved several people on behalf of the town. My recollection was Richard Gallant was there. I think code enforcement staff was there. I think Craig Lauer might have been there as well. And I think Jim Fleischman was there.
And the arborist.
And the issues that were discussed at that time were the clearing of the land without a vegetative permit, There was some materials that were being placed into the pond that was improper fill. And then there was the need for the FDA because of the clearing that had gone on.
Well, let me stop you there for a second. Was there a pond?
No
No pond. Just a,
No pond.
Yeah,
There's
there
no-
was no pond. Yeah, there was no pond
Okay.
on the property. It's where they dug and filled in
okay.
to create dirt.
I'm sorry, Glenn.
It's where they had dug in the middle of the property and filled it in with other materials.
There was, yes, it was
And-
other material.
Yeah,
right?
they
There was
filled
tile
in a
was going
pile
in
to
and things
create
like that.
more material, more dirt for grading.
And there was a determination at that meeting that they did need to apply for an FDA. There was discussion of the historical drainage and how that affected their property. That was a matter that Mr. Gallant would have been looking into. And if there was later communication between Ms. Bergthal and myself, I apologize if I did not get back to you. I'm not stating one way or another as to what I did, but there was always a requirement that they apply for the FDA. It is my understanding that they in fact have submitted an application for an FDA. But the issue here today is that they're not moving forward with respect to the FDA, and it may not be their fault. It may be an issue with the engineer that they have retained. But there are outstanding comments that have not been responded to. And so we're in a holding pattern and wish an order directing them to move forward. At present, I do not believe there are any fines running against them with respect to this. There, you will not be asked to impose fines today. It's a finding of the violation, and there would be a time given by the special magistrate to complete the FDA process before they would they would face a situation in which fines might be imposed.
And is there anything else you'd like to add with her, with regard to her statement that she's allowed under state law to do what she did to protect her property from flooding? That I have not heard at any of these hearings, so I would be curious.
I am not familiar with the state statute that she is referring to. There has never been a position with respect to this property that they did not require the FDA. My understanding is that there is an application for the FDA that has been submitted, but it is not being moved forward at this point in time for whatever reason.
Ma'am, if I may?
Go ahead.
So Mr. Curtis is right with everything he said, except we had that meeting with several gentlemen,
Mhm.
and this is where my real problem lies with the situation, is that I then, after this meeting, did some research and contacted Jeff and asked for a meeting. And I sat down with him and explained what I explained to you about the neighbor flooding me, the neighbor to the west having eliminated her drainage ditch. So we can't drain anymore, and we're not draining, and our property and house is being flooded. And this is why I did what I did. And he said to me, he will get back to me, because I said, I truly do not believe I need an FDA for that. And he told me he would get back to me with the information. Now, the sad part is that even after I have had the conversation with him, and granted it was a while ago, but not only did he not get back to me, there's also not an answer as to, I mean, their violation says, get an FDA or put the drainage ditch back. that's what the violation says. Well, all due respect. So there was a mistake made with allowing the neighbor to the west to eliminate her drainage ditch because somebody wasn't paying attention to say, oh no, we need that for the entire row of properties to drain. So that was an oversight from somebody. And now we are suffering the consequence from that and are the ones that are in the wrong. And I have been in communication with them. And instead of addressing that and not getting back to me, it goes back to, oh, well, she's not moving forward with the FDA. I don't even want to address that just yet. I'm sorry, because my point is not being addressed. I am not somebody that's not trying to do things right. I have been in communication and we are facing the issue with being flooded.
So I understand that and I hear that, but what the only thing that's before me today is whether there's a violation of the town code and whether or not you're required to get the FDA permit. So as it relates to meetings that you've had with town staff in the past and whether people followed up with you, I can't do anything about that today. Did you follow up with Mr. Kurtz when you didn't get an answer? I mean, this looks like it's been going on for quite some time, so.
Oh, for sure. But this is also, I had a conversation with them 2 weeks ago. They actually called me.
Who's they?
Sandra called me about,
Who's Sandra?
Sandra at the front desk of
Okay.
at permits, I think she is. She's super nice. And I have been in here a lot. I mean, if you ask her, I mean, oh my Lord, to try to move these things along and get things going and move on. Oh God, now I just lost my train of thought. Oh, right, 2 weeks ago, and she called me and I had a conversation with John and Jeff on the phone, and they said to me, oh, either way, we will get back to you before this hearing with an answer to the summary and what this is actually all about. Nobody got back to me.
Okay.
But this is the thing. It's like, it's not that I am not the one that isn't trying. I'm trying to do all the right things. And then they try to slap me for a $750 extra fine. You will find it in there because it's a code violation. Well, it should have never been a code violation because I am complying. I am in communication. All Jeff had to do is say, okay, look, we looked into this with the neighbor to the west, this is what we do. Oh, this is what needs to happen for all of that. That's all that needed to happen. And now it's a code case and we're standing in front of you wasting time with this where I would have done whatever needed to be done, but I wanted clarification because I have, these are the issues and they're real. Our property is being flooded. Our house is being flooded. And nobody ever got an answer about it either way.
So
Anyway.
let me ask you this. Do you still have Jupiter Civil? Are they still retained by you?
Well, and this is the thing. So
Okay.
I hired they did the initial FDA application and UVA and the plans as to what should happen.
Right.
Because we now decided since then we want to develop the property, meaning we want to put a barn and a cupboard and all of that. So which we need the FDA anyway for,
Okay.
which is all good. But the problem is Jupiter Civil, this relationship didn't work out. So I did let them go. And I have now retained LDI. This all unfortunately brought everything a bit to a screeching halt because the holidays and then he was on vacation and to try to get them up to speed and with the comments and all of that, you know how it is. So this isn't us not moving forward. And I actually have informed Sandra with permits here of that very fact. So she knows that, that I had to switch engineers and all of that. So this is, again, not us not trying to do the thing, but this is also a lot of work and a lot of going back and forth with the engineer of what we want to have happen with the property and how to make this all the right way. I mean, it can only go so fast. But this is not us not doing anything.
Okay.
At all.
How quickly can you get the permit for whatever it is you're trying to do submitted?
Well, I already submitted the permit.
For everything that your new addition and whatever else you're trying to do? When did you submit?
FDA was submitted, right?
Yeah, there's FDA, this was all submitted
They came back with
with
comments.
comments and then.
So you haven't addressed the comments. Okay, so how
Well,
quickly
because
can your
I-
new engineer address the comments?
Exactly, but this all is taking some time, but this, again, I paid the permitting fee, I did all of it.
So how long from today till your engineer can get resubmitted and you can get an FDA permit done? Does your engineer have all the drawings? Is he working on all of that?
He has, well, he was on vacation for 2 weeks and then the holidays and all of that, and I would like to get if possible, enough time, because it's a big project, and he now he looked at it briefly and he says, oh, we have to do this all different and this and that, and oh my lord, and it's
Well,
like,
That was after the first submission and getting the comments back that we realized the other engineer really didn't know
what he was doing.
what he was doing.
Yeah, okay.
And
So he needs to go through this whole thing again. It's not like he can
I
kind
mean,
of use.
if we could get just a few months of just trying to get this really right, because it obviously costs the town engineers money and hours and to try to get it right instead of quick and then it's not
Yeah,
right. It's just
no, yep, I
it
get you there.
came to light that a lot of things needed to change. But again, yeah.
So let me ask Mr. Suarez a couple of questions. First, you cited them for 175, 170, 175, 110, and 175, 240. The pictures in here clearly show that there was earth moving and clearing activities that would require the FDA permit. Is there anything in the code that allows work under emergency scenarios to be done? In that section 175, let me be specific.
In emergency scenarios, I mean, work would be allowed, but then they would still have to apply for the permit after the fact.
And does the code specify a time frame? Typically, codes say you can do emergency work,
That
you have
I
to get a
do not-
permit within 5 days
I
or
do
7
not know off the
days.
top of my head.
Okay, but there's no carte blanche authorization under the town code that if it's an emergent situation, you can do whatever you want, you don't need the FDA.
I'd have to get back to you on that. No,
That's pretty important. Can we pull up the code?
Yep.
Because I only have what was cited in the notice of violation. And then the second question I have, Mr. Suarez, is do you have a signed copy of the notice of violation and notice of hearing for today?
I believe I do.
Can you,
Yes. I'll
can
bring
you
it
go
up.
get that?
Did want to state for the record that, of course, it came from a complainant. No one in town contacted code, came from a complainant. That's when we opened the case. And based off prior conversations with Craig, when he was there in December, that's how we obtained the pictures and enough evidence to go forward with the FDA violation.
Okay. If you can get me the signed copy of the NOV, NOH. Ms. Thomas, are you accessing the code?
I'm trying to, yes.
Thank you.
You're welcome.
All I have are just the sections that are in the
Yep.
NOV.
Okay, 175, 170 just states development for which a floodplain development permit or approval is required shall be subject to inspection. That's all that one says. Then 175, 110, let me pull that one up. I apologize, it's going slow. Okay, so under 175-110 permits required, it states any owner or owner's authorized agent who intends to undertake any development activity within the scope of this article, including buildings, structures, and facilities exempt from the Florida Building Code, which is wholly written or partially within any flood hazard area, shall first make application to the floodplain administrator and the building official, if applicable, and shall obtain the required permit or permits and approval or approvals. No such permit or approval shall be issued until compliance with the requirements of this article and all other applicable codes and regulations has been satisfied. And then 240. $175, $240 states violations, any development that is not within the scope of the Florida Building Code, but that is regulated by this article, that is performed without an issued permit, that is in conflict with an issued permit, or that does not fully comply with this article, shall be deemed a violation of this article. A building or structure without the documentation of elevation of the lowest floor, other required design certifications, or other evidence of compliance required by this article or the Florida Building Code is presumed to be a violation until such time as that documentation is provided.
All right, and there's nothing in there about emergency work.
No, ma'am.
Okay. All right, and then is the town, Mr. Suarez, I don't think I heard you say, are you seeking administrative costs for today's hearing?
We are seeking administration costs, Your Honor,
And is the amount?
$234.05.
Okay, and can you show this to Ms. Berchtold? Any objection to that being added to the file, Ms. Berchtold? It's just a signed copy of the same notice that you reviewed in this case file.
That's fine.
Okay, thank you. Thank you. All right, anything else, Ms. Berchtold?
Yeah, I would really kindly ask you to not impose a fee for this hearing on us, because again, there wouldn't have to be, if Jeff had just gotten back to me like he said he would, there wouldn't be a code violation, because I would have just done what needed to be done, and he chose never to get back to me. Same for the $750 extra fee for the permit, because it was a code violation. Well, it didn't have to be that. All they had to do is get back to me, and they just never did. And even now, when they said to me 2 weeks ago when we were talking on the phone, and Jeff said, either way, we will get back to you before this hearing. Because this is truly, oh, why is it not being moved forward? They know.
So I hear that. Let me ask him to respond. I hear what you're saying, and I will certainly take that into consideration.
Thank you.
Go ahead, Mr. Kurtz.
The FDA has to do with the fact that land was cleared. And that's the requirement. There's been an FDA application. The FDA application is not moving forward. It is apparently not moving forward because of dissatisfaction with her engineer, having nothing to do with town staff response or non-response. The comments that were issued to the engineer are dated September 19th of 2025. And we are just learning in today or possibly last week that they had terminating their engineering company. With respect to 2 weeks ago and the comments about the $1,000 versus the $250, that once again, that has nothing to do with the fact that there was a code enforcement violation. That has to do with the fact that work was done prior to the issuance of a permit, and therefore there is a quadrupling of the permit fee, despite the fact that at this point in time, The town has received $250, not $1,000 for the permit fee. We have been processing the FDA application. The issue that was discussed with respect to the $1,000 versus the $250 was there had been apparently some application for a reduction in the fee. And that our Richard Gallant had told somebody verbally that it was denied, but had not issued anything in writing. And that is the matter we are still looking at. It has nothing to do with the reason that this hearing is taking place. And it is nothing to do with the potential of a fine. So
Okay.
the issues do not, the issues of historical drainage that may impact the FDA application. And that is something for the engineers to opine on and figure out whether or not there should be some relief in that area. Once again, that's not why we are here today. This is a somewhat unusual case in the fact that there has been an application for the FDA, but it is not moving forward. And apparently it's got to do with problems that the owners had with their engineering company. And as you well know, they are not going to be subject to a fine today. You will hopefully enter an order as to requiring them to move forward in the process and give them adequate time in light of the fact that they have just hired a new engineer.
Thank you. So, Ms. Bergdahl, just so you know, I don't have latitude as it relates to permit fees. So permit fees are set by Florida statute, by the town code. I can't do anything about permit fees. The only thing I have latitude on is the administrative costs, which based on your argument, I will reserve administrative costs for today's hearing. So I'm going to give you time to comply. What my reservation means is that if you get to a fine assessment hearing and you come back to me on the date that I'm going to give you in a second, if I impose administrative costs, I could impose them for today's hearing at that next hearing. If you come back to me or if the best case scenario is you don't come back to me, with all due respect, you get complied and I don't see you again, you get your permit issued and it's done. That will mean that you don't get administrative costs imposed for today's hearing. Given the communication issues, I am sensitive to that. And this is a little bit anomalous in that this is going back quite a ways and you're finally to a hearing. So given what you said, I'm going to reserve on those. My hope is that I don't have to see you again and you get complied out, because it sounds like you're trying to get through the process, but it's taking a bit of time. So I'm going to give you the latitude to get through the process, and I'll reserve those administrative costs. But
Thank you.
I can't do anything about the permit fees. So those are what they are by state law and by town code. So you'll have to address those with the town. Is there anything else you'd like me to hear before I make my ruling?
No, I think that's good, yeah.
Okay. Anything further from the town? All right, in case 25050004, I've entered both sides' evidentiary case files. As it relates to service, I'll find that the town had good service based on the notice documents in the case file, which include an affidavit of posting for the most recent notice of violation and notice of hearing. I'll find based on the photographs in the case file, as well as the testimony of both the code enforcement officer, as well as the respondents, that the respondents in violation of sections 175, 170, 175, 110, and 175, 240 of the ULDC of the town code. I'm going to require that you comply with those sections, which means having the FDA permit issued on or before February 27th, 2026. So I'm giving you essentially 90 days to get the permit issued. If you don't achieve compliance by that date and have the permit issued by the town, a $250 per day fine will start to run on February 28th. If you don't comply by February 27th, you'll need to come back to me at the March 2nd, 2026 fine assessment hearing. And that will be the hearing that I actually impose the fines at. As I've indicated to you, although I have found you in violation, I'm going to reserve administrative costs for today's hearing. So ultimately, your goal should be to get that FDA permit issued on or before February 27th, and then you don't have to come back to a subsequent hearing. If you have to come back to a subsequent hearing, if you don't have the permits for whatever reason, come with all the evidence that you have at that hearing and explain to me why you haven't gotten the permit issued in that time frame. Because although the FDA permit is a little bit more complicated, that 90-day period should be plenty of time for you to get through that process, especially given how much time has already gone by in this case. So I will reserve those administrative costs, and I wish you the best of luck in getting the permit, okay?
Thank you.
Thank you. Next case.
It's Peter Graham and Melissa Martz, address 14817 Snail Trail, PCN 4141-4317-01-309-0080, case number CE 25-28. Code sections ULDC 70-015, maintenance of swales and culverts, ULDC 70-020, drainage to be contained on site, ULDC 70-025, culverts required.
Code Compliance Officer John Suarez presenting KCE 2528 in reference to the property located at 14817 Snell Trail. Notice of hearing, notice of violation was posted at 14090 North Road on October 3rd, 2025. Copy of the same was mailed via certified USPS from the owner of the property appraiser on October 3rd, 2025, and a copy was also posted at Town Hall on October 3rd, 2025. This is a drainage culvert issue. There's blockage underneath the driveway culvert that is impeding the flow into the canal, causing flooding issues on the surrounding properties, because there is no flow underneath their culvert, underneath their easternmost driveway. They have two driveways. We have been in email contact with the property owner, as well as Public Works Superintendent Craig Lower met with the property owner a few times, I believe, and explained the violation and ways to comply. At this time, we are requesting that property owner be given 15 days to clear out anything impeding the culvert to allow for proper drainage. We did go out this morning because they did send an email stating that they complied, but there is still blockage, which we have photos of as of this morning, I believe around 8 in the morning. The violation continues to exist after December 15th, 2025. The town is requesting $250 a day for each violation. Additionally, it's recommended that the administration costs incurred an amount of $234.05 be assessed in order to be paid to the town of Loxahatchee Groves, and prepare to submit the case file as evidence.
Any additional witnesses on this case? Any testimony?
Inspect.
Okay. Thank you. And are you here for this one, sir?
Yes, hi.
Yeah, closer to the podium. What's your name, sir?
My name is Peter Martz. I'm the property owner.
All right, give me just a moment to look
Of
at
course.
the case file, and then I'll have Mr. Suarez hand it to you to look at, and then we'll go from there. All right, Mr. Suarez, can you show this to Mr. Martz, the case file? Same thing you've heard with all the other folks. Take a look through the case file, and at the end, I'm gonna ask you if you have any objection. Take as long as you need. There's a bunch of paperwork in there.
Which one was taking this one? That's all I really care about. I mean, I thought I had it resolved. I've spent countless hours, tons of money. I've actually been in the canal with a 30-foot power washer, and I've had flow go through it. I have videos of the flow, so I want to know which one it was. Okay. Yeah, I mean, I just had flow through that. Okay, so basically this in particular.
So let's start with the easy part before
Okay,
we get into the
here's
hard part.
Here, let me just
Let-
tell you.
But hold on, let's start with the documents. Do you have any objection to those documents being entered? Okay, go ahead.
Okay, so I have two driveways. Under both driveway is a pipe. right?
Okay.
I bought the house in 2020. I had C Road was a dirt road, Snail Trail was a dirt road. No problem. I drive a little sedan, became a problem when it rained, started to get bumpy.
Mhm.
I started to be a pain in the butt to Mr. Shore at the time. We've got Mr. Peters, who was leveling, or excuse me, who was grading our road at that time to get on the schedule more frequently.
Okay.
Because I don't think we were being serviced as frequently as we should. I was a thorn in his side, and then basically that caused them to go from grading to leveling, where they pushed it off to the side. Eventually, during the rainy season, if you look at the topography of Snail Trail or 19th Street, my road, my second driveway and my first driveway are down, right? So when it rains, all of the road causes the water to come towards my driveway, which pushes the mud into my culvert. It is not debris, it's not palm fronds or sticks. It is literal sand from the road that comes in there. I had several people out, doesn't matter because I will get it resolved, and I thought it was resolved. Several professionals out, excavators out, money out of my pocket, because I just want to sell my house and move. I'm so sick of the stress that this causes. My wife's sick. I'm not into it. I've been trying to resolve this, and it's virtually impossible with the way that the water is held so high because of the work that's being done at F Road and collecting canal, that the water level stays up. I rent a 2-inch trash pump, suck all the water out, have the excavator pull the sand from the road and put it right back on to the other side of the road so I can get the county to come pull it away. I've been in there blasting at it, but for the county or the town to simply tell me this was caused by me is ridiculous. I can fix that, and I will get that fixed if this is what, because I had water flow. I don't know how you got that picture. I had water flow through there. There is no water flowing now because there's no rain. So when I was spraying with it, water was flowing through. Now you see a jam and there's an area at the top. I didn't see that. That could be wider, but no water is going to flow because there's no rain.
Okay.
Water's stagnant everywhere.
Okay.
It's very hard for me, without renting expensive equipment and excavators, to continue doing this with the water level being so high until whatever they're doing. And I've tried to get the public works to open the gate and drop the level, which they won't do. But basically you can't get that mud or the road debris out of that because it's been backed up until there's no water. So it's, I mean, I'm at a loss that I've had so many professionals and other people come out and tell me that this was due to me not clearing debris and not due to the road being leveled and pushed into the canal. It's very frustrating for me. It's defeating, honestly. But I have all the equipment. I can get this solved in whatever it is, 15 days or however long you suggest.
Okay.
I mean, I've literally, it's disgusting how much effort I put into fix something that was not caused by me. It's disgusting.
So who have you had in terms of professionals out at the site?
I've had an excavator out there 3 times. I've had an irrigation company out there who basically said, I can't do any, because I was going to have the whole, I wanted to see what the professionals would do. And he basically said, while this water level is so high, you can't do anything. So I waited, and these people have been great. The correspondence, you guys have been awesome. Nonstop, literally, like 24/7. Dan is like, it's amazing how fast she is. So the irrigation people have basically said, we can't do anything until all the water's out of there. And the water is up high because of, I guess, the water district holding it up high. But I can get in there, I can suck the water out, and I can get it in there with a power washer, and you just keep adding extensions to push it all the way through. It's just, it's ridiculous.
When you're doing that, what are you pushing out? What is in the culvert?
Push on the lead work. It was
So when you,
all-
what is road debris? What do you mean when you say that?
So I live on a dirt road.
So is it dirt that's coming out? Okay.
It's literally the dirt that is from the road. When you drive down any of these dirt roads, you'll see on the side an embankment where the level of maybe higher. That is going to push. Out. So that's what I'm trying to get out. And physics doesn't allow mud to go against water and other debris very easily. It's just been so ridiculous that I've had to deal with this, but I am. So if he said 15 more days or whatever it is to have it done, I mean, you've seen the amount of work that I've done to both my driveways. I mean, I've spent thousands of dollars and tons of hours. And it's because I don't want to argue. I just want to sell my house and leave.
Okay.
Um,
What's the town's response to what he's saying?
Craig, did you want to speak to that matter?
And to come into compliance, there has to be water flow completely through it.
And just so the record is clear, your name again?
Craig Lauer, Public Works Superintendent,
And you're saying what?
that the pipe is still clogged, as you see in the pictures, full of roots and debris.
Okay.
As that I went and took the picture this morning with Miss Deanna.
Okay. And what you saw in the pipe was what?
Roots.
Okay.
It was full of roots and debris,
Okay.
as you can see in the picture.
Can I jump in? So I don't
Go
have
ahead.
whatever-
Go a little bit over there so the microphone gets.
I don't have whatever camera you have. So when I was sucking out with the 2-inch trash pump, I had the hose in there and I was blasting through there, sucking out one side, going through to the other, and I was seeing water flow. So it was clearly almost there, I guess. I mean, yeah, I don't know how you're saying there's not water flow when there was, when debris, literally bottles came out of there when I pushed it through. That had been
Understood.
jammed in that pipe since the 70s, it looked like. I mean, since way before I bought the property.
I believe it's the town's opinion that it's not road debris, it is roots and black dirt, not road dirt. That's clogging up the pipe, and it is the owner's responsibility to clear whatever is in vehicle.
So who from the town was out there this morning?
Myself and Deanna,
Okay. And what was observed to be in the pipe this morning?
me falling in the water.
Yeah.
I did. As I observed, I took my flashlight, shined it through the pipe, and took the camera, took a picture of it. As you can see in the one picture, that the pipe is still full of roots and debris,
And when you say debris, you mean what?
as in mud and dirt.
Just mud and dirt.
Yeah. And it's
Natural
full of
mud and
roots.
dirt that would have
So-
flown through if it wasn't backed up.
So in the future, what will happen is, as long as that stays in there, the first rain, what little debris will come through with the rain will back up into it, just like hair in a drain. It'll instantly clog up, and then we're back to square one again.
Yep.
that it's full of roots right now, it's a lot of work to get what he's trying to do. As if we went in and replaced it, we saw it, we would just pull the whole pipe, put a new one in.
But it's just mud. There's there's space at the top. You can see in that picture that water would flow through.
Yeah, but water flowing through that much
Yeah,
with the
but-
first stick that comes through, it's gonna clog and then we're back to square one again. It's not
But Craig,
efficient for the
I agree
town.
with that, but why would I replace that whole pipe when it's just some mud halfway through? And that mud was caused by in my humble opinion, the road being pushed into my.
Yeah, so I'm not gonna, I don't ever at these hearings, I can't mandate how you comply, but I want to make sure we're clear,
Yeah,
that you're
I
clear
just
and
want
I'm
to
clear
comply so I
about
can
what
sell my
compliance
house.
is, right? So I think
Can't
what,
sell my house with an open violation.
right, what I'm hearing from them is that it's not just some water coming through the pipe, the entire culvert has to be open. So you have to be able to look into the pipe, or the code officer is gonna have to come out there and look into the pipe and be shown that it's completely open. Is that accurate? Is that what the
Correct.
code requires? Okay, so it's not just a little bit of water coming out on one end or the other.
Sure.
It's the pipe being completely open. So how you get there, I'm not going to prescribe or mandate, but I just want to make sure you understand so that you can get into compliance. Given your understanding of that, how much time do you need to do that?
I would like 30 days,
Okay,
just because I work also.
I'm happy to give you a reasonable amount of time to comply. So I appreciate your efforts to get into compliance, and I'm willing to give you the time that you need to do that.
Because Craig, if I replace that pipe, the next owner of the property, the first big rain, anybody who lives around here on Dirt Road knows that when there's a big rain, that mud's gonna come straight into the canal. So even if I had a brand new pipe that was completely open, it would just get packed up again. Because that one side would get covered unless I build a wall or shut off my driveway. And it would just get backed up again. It's just, as long as the road keeps getting leveled, you won't see me again. Because I'll resolve it and move, but you're gonna see somebody else in a couple of years who's gonna have the same problem. And that's all because of the leveling, not the grading that was done to my road, which might have been my fault for asking Robert Shore to have it done and pestering Mr. Peters, so. Whatever.
Let me ask Mr. Suarez, can you get that case file back for me?
I mean, Craig, I can go to Palm Beach Ironworks and buy a 15-foot iron rod and get down there. Jam
Yeah,
it through.
however you get it
Yeah.
clear, like she stated, that's up to you.
And what I
I
would,
just think it's absurd that the town doesn't take any credit for I mean, I've lived there for so long and it's just so disappointing, but what.
well, the difficulty I have, and I would understand your argument, but the photographs that I'm seeing, there's some other things in there. So the dirt is difficult.
Sure.
What
I
I
agree
have his
100%.
testimony that it's not road based, that it's mud and other things. So I have
100%.
to take that testimony for what it is. I can see for myself that there are tree roots in there. So
100%.
there are some other things going on. I appreciate that there may be some,
But if you go to any
Exacerbation of it?
culvert in this town, you'll see little roots going through. We live in the swamp. I mean, to say no roots, you don't see anything around that. That's not nature.
well, but this is not supposed to be nature. This is supposed to be an open pipe.
I
So
understand.
yeah, I'm going with you to a certain
Yeah.
degree, but my more important thing is to give you a reasonable amount of time to comply so you can move on with more important things. Is there anything else you'd like me to hear, sir?
No.
Okay.
No.
And you think 30 days is enough?
Yeah.
Okay, and I would certainly encourage you, the moment you have it cleared, however you get it cleared, call Mr. Suarez or Miss Thomas, whoever you normally call,
Yeah.
and have them come out. I would take photographs.
Communicate with them a lot. They
Right.
will tell you that.
The document-
I feel like if I needed something from you, I could ask them, like, I've been pestering them. Cause it's really, it bothers me. It does, I have a beautiful property
And you don't want this,
and I
yeah,
don't want this.
yeah. So as soon as you have it
So my
done,
house-
fix,
The neighbors are selling their properties,
right,
right, which is ultimately gonna affect my property price when I sell mine, cause they're comps. And
right.
now I have all this work and it looks like crap because I'm digging all this sand out of the culvert and the neighbors are probably thinking, oh, what is this? What is this? What is this? I don't wanna live here.
Well,
Like,
make sure,
it doesn't look good.
make sure when you're done and you have called them that they give you an affidavit of compliance, so you have that for your files. That's the only thing you want, and you want that done by the date that I'm about to specify. So I encourage you just to make sure you're in communication. Sounds like you have been, continue to do that. Anything further from the town? All right, in case 2528, I'll enter the town's evidentiary case files composite exhibit 1 without objection. I'll find based on the notice documents in the case file, which include an affidavit of posting, that the town had good service for today's hearing. I'll find based on the testimony of the code enforcement staff and the utility staff, public works staff, that the respondent's in violation of section 70-015, 70-020, and 70-025 of the ULDC. And I'll require the respondent to comply with those sections on or before January 2nd. So I'm going to give you the 30 days that you've asked for. In the event of noncompliance, a $250 per day fine will be assessed for each day the violation continues. And in the event of noncompliance, though I don't expect this, you'll have to come back to me on January 5th is the fine assessment hearing date of 2026. So get it complied. As I told you, call them as soon as it's done so they can comply you out and be done with it. Because I have found you in violation, I do have to award them their administrative costs in the amount of $234.05, and those are payable within 30 days. So best of luck to you, and make sure you keep in touch with Mr. Suarez.
Thank you.
Thank you, sir.
All right, cool.
Okay.
Thank you. And where do I pay the bill? Where do
The front counter,
I?
yeah.
Ready to move on to the next case?
Yeah, it's Mr. Suarez, but he just needed a bathroom break. But yes.
You want to call it in, and then hopefully he'll be,
It's, John, Evan, and Arlene Smith. Address 14805 Okeechobee Boulevard, PCN number 41431701313010, case number CE 25-32. Code sections ULDC 20-010 G1, general provisions, outdoor storage, ULDC 20-017 prohibited uses.
Good morning. My name is Jack Rice with the law firm of Gunster Yoakley. I'm here on behalf of the respondent. I have not been sworn in if we want to check that box for procedural purposes, but Mr. Suarez just walked back in.
if you want to be sworn, I'm happy to swear you. Either, whatever your preference.
If it's town tradition to swear in attorneys, I'm happy.
Typically not unless you're, yeah, so
I
you,
would prefer not to.
all right, so no swearing?
Ma'am.
Okay, thank you. Go ahead, Mr. Suarez.
Code Compliance Officer John Suarez presenting case CE 2532 in reference to the property located at 14805 Okeechobee Boulevard. Notice of hearing, notice of violation was posted at 14090 North Road on October 30th. Oh, I'm sorry, 14805 Okeechobee Boulevard, October 30th, 2025. Order finding violation was mailed certified to the property owner from Palm Beach Property Appraiser, October 30th, 2025, and a copy was posted same date. The violations that exist are section 20010 outdoor storage, section 20017 prohibited use. The property use code on this is single family on this property. We have been in constant contact via email with Mr. Rice, which he's the counsel for the property owner. He stated he will seek a special exemption approval to operate a hauling company at 14805 Okeechobee Boulevard. They have hay operations on site, including hay storage, transport, and dispatch. They also have up to 3 employees involved in transport. So the town is requesting at this time 15 days to file the document with a business enterprise. And then after that is in, requesting 90 days for the council to approve or not approve the application. Additionally, it is recommended that the administration costs a certain amount of $434.05 be assessed in order to be paid to the town of Waxahachie Groves. have the case folder. Submit it as a.
All right, let me look at that real quick, and then once I've looked at it, you can show it to Mr. Rice. And while I'm looking at this, you cited them for outdoor storage. What is the outdoor storage?
The outdoor storage you'll see in the aerial views on property appraiser, it's also storage of trucks, I believe, and containers. For the hay business, the whole,
For what business is it? It's a hay business?
hay, all,
Okay.
that's what the maybe as you know. The other use code is single family. Which you don't business at this time.
And where is that use code coming from?
The use code is from the property appraiser. For the record, we have sent over the link to submit all documents, Mr. Rice.
The link to what?
There's a link for him to fill out the forms and the paperwork for the proposal that he is requesting for a business enterprise to be conducted at that property address. Because right now it's prohibited, but he was given the option of either cease and assist the business or proceed with his request to do a business enterprise, but that has to be approved by council, and he is aware what has to be filled out and submitted.
Mr. Suarez, you have multiple affidavits of posting in here. Did you post this site multiple times?
We did remove it, so yeah, I did post it a few times.
And what was the reason for the,
Request an extension and we
Okay.
removed it from last agenda. Reposted.
Basically, it was to give them time to figure out what they wanted to do.
and there's a 2024 vegetation removal permit in here. What's the relevance of that?
Just added it for evidence because they remove vegetation, but now there's so much storage there that. I mean. It may coincide with the other. They removed it for the storage of trucks and the business.
Okay. And you have Division of Corporations paperwork in here showing that there's a Barrows Transport and a B&E Equestrian Services that have a principal address at this site. Is that, those are the businesses that are operating there?
Correct. In the email with Mr. Rice, I believe he mentioned the equestrian, which is inactive in Sundays at this time. Yes, it's referenced in the email I attached.
Okay.
Active.
Special magistrate, I do have some objections as to the photographs in that specific document. If you want, I will hold
Yep,
back
well,
on raising them.
yep, we'll get there. Let me just look through the rest and then I'll have him show you the file and you can give me any objections that you have. All right, Mr. Suarez, can you show Mr. Rice the case file? And you've heard all the statements I made to the prior respondents. Take a look, take as much time as you need. There's quite a bit in there. Let me know if you have any objection to any of the documents.
While I'm reviewing this, can I pass the special magistrate as well as the town attorney a copy of a Florida statute that they can review while I'm going?
Yeah,
through it?
please give it to Mr. Suarez and he'll give it to Mr. Kurtz before I see it. Any objection, Mr. Rice, to those documents?
Special magistrate, I have some cross-examination of order as to the photographs to the extent the town intends to rely on the property appraiser's aerials. I'd offer that they're prohibited by section 93.934.50 Florida statutes, as well as have some cross-examination related to them.
What was the statute you rattled? 93 point what?
934.50.
Thank you. So you're objecting to just the aerials?
Yes, ma'am.
Okay.
And then I do not actually see it in the special magistrate's copy of case file, but earlier I thought there was a Sunbiz registration for Barrows Transport.
It was in there.
Okay. Barrows Transport and Barrows is actually the prior owner of the property, as is evidenced by the actual property appraiser's ownership.
Okay.
history
Yeah, I
here.
saw that. I saw that bar
So I would ask
arrows.
it to be excluded as it's not my client.
All right. Any other objections?
Just the cross-examination and questions related to the photographs to the extent you bring them.
Yeah, you can, I'll give you time to do that.
Okay.
All right. So give the case file back to Mr. Suarez. Do you have any, you had a statute, is that what you had, gave to Mr. Kurtz for entry into the record? Is that it?
Copies there. There's one for the town and one for you.
And that's all you have in terms of evidence?
Yes, ma'am.
Paperwork, okay. So with that, let's just get the documents out of the way. I'll enter into the record the town's evidentiary case file as composite exhibit 1. I'm going to enter that over objection. And I'll also enter Mr. Kurtz, any objection to the statute provided?
No objections.
I'll enter what I'll mark as Respondents Exhibit R2, which is a copy of 934.50 Florida statutes. I'll enter that without objection. Go ahead, Mr. Rice.
Regarding my voir dire related to the photographs, do you want me to address Mr. Suarez directly or?
Yes, please.
Mr. Suarez, I'm basically going to ask you some questions that are typically known as cross-examination. You can respond to them with yes or no, unless your attorney objects or tells you otherwise. I'll speak collectively regarding the case file. Were the aerial photographs that are in the case file taken under your supervision?
We did not take the aerial photographs. It was from the property appraiser's website, their area.
Do you know what dates those photographs were taken, sir? Yes or no will suffice.
No, I don't.
I can pass the town attorney a black and white copy of the case file that I was previously given.
Oh, you need the case file back? Is that what you need?
Well,
And Mr. Suarez, do you know if any of the photographs are clear and accurate depictions of the property as it exists today?
I cannot tell you what then. I could only go off the image of the satellite.
That's all I have for Mr. Suarez.
Okay. Any other cross-examination?
No, ma'am.
Okay, you can proceed with your standard
Thanks.
testimony then.
So in general, I think there's been some confusion between my client and the town itself with regard to the uses that are permitted at the property. But the only evidence that's in the file is my correspondence with the town regarding a development application. Earlier, we were calling it a business enterprise. I believe it's a residential enterprise. And there's still some nuances related to that I need to iron out with the town attorney related to agriculture. But we are going to proceed under one of those two routes. So, I mean, my argument really there is that I would say my correspondence is not necessarily what I would call substantial evidence to meet the company's substantial evidence and anything from it, because anything arising out of it requires an implication. But nevertheless, we are intending to pursue the applications or a permitted use after discussions with the town attorney.
And when you say applications, I don't mean to interrupt you, but just so I understand what you mean. What do you mean? You mean?
There's some confusion with the outdoor storage in the town code. I don't know if you have a copy of the ordinances in front of you, but the actual section that that's referenced for outdoor storage, I believe it's 20010G. I think if you look down at subsection 2A as well as 3D and then further under E, you'll see some provisions related to construction vehicles, farm equipment, as well as commercial vehicles at properties. I think specifically with regard to farm equipment, it's allowed to be at the property so long as it's not any rights of way. I'm speaking from memory, so somebody is welcome to clarify. And then there's another provision that actually allows commercial vehicles. But it states that the commercial vehicles must be screened. If there's more than two, I think it states that there must be screened.
Okay.
Certainly, I think the property owner is allowed to own a trucking company and then be employed by a trucking company. And that the trucks come, basically parks them at their home at the end of the day and then drives to work, but they're not actually actively engaged in trucking at the property. But anyways, we're trying to iron out those understandings with the town. So really all we're asking for today is that either the case be continued for us to resolve our differences with the town, as well as possibly to pursue the development application. So I think the town is seeking a violation and we're seeking a continuance, and our request would be for an equal amount of time as the town is requesting, which I believe is 105 days.
Mr. Suarez, what was your remedy request in this case?
It was to apply within 14 days.
Mm-hmm. And then 90 days
And
to,
90
yeah,
days.
okay. Does the town have a response generally to Mr. Rice's statements or requests for continuance?
This for a statement for outdoor storage, any outdoor storage would be incidental use to the property, and since the use code is single family, no outside, there's no incidental use for the storage area on the property. We don't have an objection to 105-day continuance.
Thank you.
Is that a straight continuance? So no fun, or are you seeking a finding of violation today, or do you want to have discussions outside of this process?
We have.
Okay. So. $105 is a very random number. So would that be the April hearing or the March hearing?
I think
April hearing? Are you in agreement, Mr. Rice?
Yeah, I think I heard 104 or 105, but an April hearing's fine.
So that would be April 6th. And Mr. Rice, you're in agreement?
Yes, ma'am.
Okay. All right, so with that, the only thing I need to find additionally, I've entered both sides. I'll ask that to the extent there's a hearing on April 6th, that this evidentiary case file, which also includes Mr. Rice's Exhibit R2, comes back to me in the same form that I saw it today. But the only other thing I need to do on the record here is find a legally sufficient service, which based on the documents in the case file, the notice documents, which include an affidavit of posting, as well as USPS delivery confirmation of the certified mail. The town had good service for today's hearing. So with that, in case CE 25-32, I will grant the mutually agreed continuance, and I will reset this for a violation hearing on April 6, 2026 at 9 a.m.
Thank you, ma'am.
Thank you. Next case.
The next case, Scott and Christina Devine, the address of 1037 F Road has been removed from the agenda.
Being pulled from the agenda. Very
Yes.
good. Thank you. Next case.
So then the next case, is for petition to code enforcement special magistrate to determine compliance. The property is listed as, the property owner is listed as Eldad Iskovich, address 1032 Hyde Park Road. PCN number 41 41 43 17 01 535 0030. Case number 202006-122. The code section was under the ULDC 175-110, permits required. The petition was requested by Katie Edwards Walpole, for the property owner, Eldad Iskovich. And I'm going to defer it to our town attorney. Jeff
And
Kurtz.
let me just ask for one clarification, because the documents that I got, I think there were two petitions, right, for two different case numbers.
Yes. There's an amended petition that we have.
I have documents for case number 2309, also 0001. So, Miss, I just want to make sure that that's added. I guess we need to add that to the agenda because there's only one listed on here.
Okay.
Ms. Walpole, is that accurate?
Madam Magistrate, thank you. We did submit two, however, the item that was published for petition for hearing today is the case number ending in 6122. So since that is the only petition that was noticed and before you, we are prepared to present on that petition alone. And that's just for
So you're-
notice purposes.
So you're not requesting hearing on 2309-0001?
We did, however, that's not what's on the agenda today.
So you're requesting that be placed on a subsequent agenda, is that correct?
Yes, and in fairness to the town, I've been in contact with the town attorney. So I believe when he is ready to present, we can take up the petition. The second petition that was filed, but again, the one that's on the agenda today, there's only one agenda, or I'm sorry, only one petition before you today.
Okay, very good. So then, given that, I will stand corrected and leave it well enough alone with the one that is on the agenda. So, Mr. Kurtz, go ahead.
Well, it is, Ms. Edwards' petition. So.
And let me ask,
I think that we have got a basic resolution of this matter, is my understanding based on our conversation with respect to this particular.
I just want to make sure she can hear you. Can you hear him, Miss Walpole? He's not, I think he needs to be on the microphone.
Yes, thank you for asking. It is, I can hear the magistrate just fine. It is difficult to hear Mr. Kurtz, however.
Okay, thank you. We're resolving that now.
Thank you.
I was gonna say that petition is the respondent's petition. So, but I think that we have basically resolved the issues, but I'll let Ms. Edwards Walpole.
And let me just, before we get too far into any discussion on merits, let me ask you, Ms. Walpole, I received the documents that you submitted in advance of this hearing, but what I just want to be clear about is there are a lot of cases that come through the town's docket that I ultimately hear. I just want to make sure I'm clear. Was this matter appealed, this original order?
This one was not appealed originally. I was retained by the property owner at the end of January, and I have been working with him mainly in the capacity to get the permits and to bring the property into compliance. And so the one that you have before you today deals just with one specific portion of the code, and it relates to the FDA permit application and when the town would consider compliance achieved, whether it would be when we submitted the application for the FDA or subsequently other permits thereafter. So that's really what we're trying to determine is as we continue to work through the permit comments and issuance is when the compliance is achieved, what benchmark constitutes compliance. And then the second issue, I believe it relates again just to the requirement to obtain the FDA. We have one violation, and then there is an order dealing with a repeat violation for the same section. So even if we need to continue to give time for additional factor review, we understand and appreciate that. However, those are really the two issues today is for compliance as it relates to the FDA and the original order and the finding of repeat violation.
All right, so both parties are in agreement that for case 2020-06122, that matter was not appealed to the 15th Circuit. Okay.
And so, with respect to
the FDA. It is the, issuance of the FDA and, the ultimate, satisfaction of the work that is required under the FDA. That we are looking for as compliance. I think with respect to, there were several cases, that were brought. And although they cited the same section, they had to do with different issues or triggers, causing, there to be an FDA. And so in one case, it dealt with the rear of the property, if you will, and clearing and development of a ring. And then there was the construction of a barn. And then the subsequent item of the repeat violation had to do with mounds of dirt and materials on the site. So although the same section was cited, it was 3 different instances that triggered the necessity of an FDA. And so the magistrate found that there was violation in all 3 circumstances and assessed fines. The resolution of the FDA cases is the application for FDA that has been submitted. They are in the process, and it is the issuance and then completion of whatever works are necessary pursuant to the permits that is issued is what we would view as compliance. And I think one of the respondents' questions has to do with the processing of the application. I think we have reached an agreement that the respondent's engineer and the town's new FDA administrator would review what has been submitted and get clarification as to what is necessary to move that application forward and get it issued. I don't know if there are further questions with respect to what the town's position is on compliance.
Does the town have hard copies of what Ms. Walpole submitted?
I'm there. And this is just my case file.
So. The hard copies are not.
I guess specifically what I'm looking for is the order in case 2020.
The order in case 2020
Yes.
06122.
Yes. Do you have a signed copy of that I could take a look at? Ms. Walpole, I don't think I think I got amended petitions, but most of the supporting exhibits were for the other case that's not on the agenda. So I just want to see the order.
That's
Thank
fine. I believe that this one, and I was trying to keep it separate, and not get into other issues. This is the one that was 166 pages, and I believe it's under Exhibit 2. The original order assessing fine.
So did I hear Mr. Kurtz correctly? The FDA permit has not been issued still? Is that correct?
We made the
No.
application for, yes, we made the application for the FDA. And then we're told we needed to apply for a land development permit. The one thing I would point out, though, I was listening to some of the comments earlier with respect to timeframes, is the bill that went into effect January 1, 2025, that was House Bill 267, that addresses the timeframes for determining sufficiency, completeness, and processing. And while I was waiting, had a chance to take a look at that. And again, that was House Bill 267. And that includes site plan approvals, not requiring public hearing or notice, as well as lot grading and site alteration. And part of our concern is that this would not be, a years-long endeavor to process the application, but in trying to come prepared with the requirements for the FDA itself. And then, of course, working through any comments that the town may have on their side. Would point out, Mr. Gallant is no longer with the town. The reviewer who was assigned to this application is no longer there. The client's engineer of record was able to pop on for a bit. He had to leave. But we want to make sure, obviously, we can address those comments timely and completely. But there are statutorily timeframes for both sides to do just that.
I think you had inquiries, what was it, November 7th? Is my recollection of the inquiries you made with respect to the comments that were previously sent by our reviewer.
Yes, part of that was the requirement, the comments to obtain was a road or a driveway, I'm sorry, a right-of-way permit. And so we had sent a letter, which is more in legal nature, looking at the designation. Is it a road or is it a driveway access easement, to make sure that we're not experiencing some of the concerns you heard today over, whose ability to drain off site. Is it on the property? Is it an easement? What exactly is this area? So that we know additional types of permits that may need to be required, primarily to keep.
Well, I guess I'm not understanding. Let's just be clear about what the task is here for me today. So the order that's dated May 17th, which is why you've requested this hearing.
Yes.
It says, should a dispute arise concerning compliance, either party may request a hearing before the code enforcement special magistrate on the issue of compliance only. So what is the issue about compliance? If the testimony is there's no FDA permit issued, what is the issue?
Well,
why is there ambiguity about compliance?
The issue is we submitted the application for the FDA, going through the checklist of what was required to do just that: updated survey, the technical information, make the application. Okay. And then we're told, right, it's still being processed, going back now to June. Then we're told, no, you need to apply for this type of permit. I don't have any end in sight as to how long it's going to take to reach compliance. Is it when you submit the application and someone determines it's complete? We're supposed to have clear guidelines to make this application. I come, with a survey within the last year. I have technical information for them to be able to review, to check the boxes for compliance with something. It cannot be a regulatory whack-a-mole where we're constantly having to figure out what else might be needed.
Well, I wholeheartedly agree with you.
Yeah.
I wholeheartedly agree with you on that. But what I also want to be sensitive to is that this is not a second method by which you can create a record or do some other appeal. This is only as it relates to how you are to comply. And by reviewing the order assessing fine, the respondent did not appear at the hearing where I issued that order. So that's the hearing where there can be discussion. And that's the hearing where you've heard all of these hearings. You've been on the computer now for over 3 hours listening to what it amounts to comply with each of these code enforcement cases. So I don't know why the respondent didn't appear at that hearing, but I don't even think that matters here. The order that I signed found your client in violation of section 175-110. So let's look at the language of 175-110, and I'm going to read it. It says 175-110 permits required. Any owner or owner's authorized agent, hereinafter applicant, who intends to undertake any development activity within the scope of this article, including buildings, structures, and facilities exempt from the Florida Building Code, which is wholly within or partially within any flood hazard area, shall first make application to the floodplain administrator and the building official, if applicable, and shall obtain the required permits and approvals. No such permits or approvals shall be issued until compliance with the requirements of this article and other applicable codes and regulations has been satisfied. So as I read this code section, compliance is obtaining the FDA permit, period.
Okay,
Not completing the work required under the FDA permit, issuance of the FDA permit. However, I will note that the last section there, or the last sentence, says you have to comply with the code requirements of chapter 175. So whether there are additional things that the town requires you to do as part of the FDA permit, I can't opine on that here today, but I can tell you with 100% certainty that compliance with 175-110 is issuance of the FDA permit.
is that from 2017? The code provision, that's what we looked at as well. We've been waiting in good faith for the town to update
That
that
is-
FEMA regulations, which another delay. So I understand the frustration. I watch the meetings and we're all trying to figure out what we need to do, what information to come prepared to satisfy the floodplain criteria. Not for lack of trying, but I'll probably be here in a year asking the same question. What does it mean to achieve compliance? That's been the question. So when the fines are going at X amount per day, there's no incentive for the town to enable us to come into compliance, process the application with the criteria that was set forth on a piece of paper.
And I think that
And that's what I'm trying to figure is when do we achieve compliance?
issuance of the permit is like with special magistrates indicated.
My understanding of the code and my read of that section of the code, and that has been my interpretation of that code all along, is that people standing before me for FDA permit violations, issuance of the FDA permit is compliance. So once the town issues you the FDA permit, the code enforcement case is technically complied and you're done.
Okay,
So given this request, what I have not historically issued a subsequent order after these types of hearings. What is the desire of the parties in this at this time? And this was your request or your petition, Ms. Edwards Walpole. What is is that sufficient on record testimony or on record determination or what?
well, obviously there is a desire to continue to work to process what's before the town, whatever application or mechanism they call it a week from now. The desire remains the same and the engineer of record just joined. We want to make sure we're very clear on what compliance is and all of the permits and approvals that are required. There should not be any more surprises or additional things. I mean, the code is the code. We made the application. We want to complete it and get the permit issued, but do it within the timeframes of state statute. That is it. And I would say I'll leave it at that on the merits of the code and the policy decisions. And, I have to look at federal and state law first. And any client, bring them into compliance, what that means today, whether or not they've had a chance to update their code or not. That's always the underlying goal, is to do it once, measure twice and cut once. And in this case, we want to make sure we're doing it correctly. And whatever has been asked, that we're responding. And again, I want to make sure if the requirement was to apply for the FDA, I think I had heard earlier, once you make the application, the permit is issued, then, we'll have timelines for completion as it relates to building permits. That's fine. We understand that. But we're trying in good faith to understand, what is going to achieve compliance. And I don't know that there's resolution on that, but certainly the engineer is willing to work with the new person who's coming in We don't want to experience protracted delays unnecessarily. If it's get the land development permit, then that needs to be very clear. That's what's going to achieve compliance. If it was apply for and obtain the FDA, then obviously we have statutory timeframes for making the application and for the town doing its part. And that's been truncated by the state legislature. I disagree with the sentiment that there is no time frame. That is not state law. So obviously we want to come prepared. We want to be very clear on what it's going to take to have a permit issued, to make a permit application, and what all goes into it so that we can truly be in compliant and then move on. I think that's fair to all sides, and that's been a recurring theme in observing these meetings. Everyone's asking a lot of the same types of questions.
Well, yeah, and in fairness, and again, I don't want to get too far down the rabbit hole because this is not an appeal. This is a determination strictly as it relates to the issue of compliance. But what you haven't heard in any of the prior cases is you haven't heard me mandate a time frame by which any respondent apply for a permit. That is not required by the code. The code requires that you obtain a building permit, obtain an FDA permit, obtain whatever vegetation removal permit, a tree mitigation permit, whatever the code is, not that you apply for that. So I do not typically like to bifurcate them that way because technically compliance is not applying for anything. Compliance is having the actual permit, whatever permit it is, in whatever case we're talking about, having that issued. And I just want to make sure that you look at your notice of violation too, because what it says for corrective action in this case is obtain necessary permits. So that is a second suggestion as to what it means to comply with this code case. So, you know, I can't deal with if there are communication issues outside between the parties and there are other issues, you may have some other legal mechanism. I can't opine about that. That's not before me today, but what I can tell you is that the code section that I read into the record previously is pretty clear. Obtaining the required FDA permit is compliance. So I don't think there's any ambiguity there. I have certainly not ever applied their code, the town's code that is, in any other manner than that. It's always been obtain the permits, not do anything else but obtain the permits. And once you have them in your hand and they've been signed off on by the town, then you're out of code enforcement trouble, if you will. So that will be my opinion. I guess for the record, how does this need to be memorialized? All right, we'll just have the minutes. I'll ask that the minutes of the hearing reflect that determination. Are you in agreement, Ms. Edwards-Walpole?
Yes, I mean, for this case, the other items that you referenced, the building permit, that part has been signed off on.
No,
by
I'm sorry. I didn't mean to
officials.
complicate. I was
That's
just
okay.
speaking generally, any permits, not specific to your case or your site or your client, just generally speaking, any code section that says you have to have a permit to do whatever it is, not specific to your site.
Yeah. What may be helpful is if Ms. Walpole and I work on a stipulated order, and I think what you want is an acknowledgement that you have made the proper application for the proper permit. And that the issuance of that permit for which we've already made an application is going to be sufficient for us. And I think we can give you that stipulated order, which you can sign off on. And, you know, I'll just, the reason I'm referring to it that way is we can actually reference the permit application that has been submitted.
That is totally fine with me. Is that, does that sound sufficient to you, Ms. Edwards-Walpole?
We're amenable to continuing to work through these steps to achieve compliance, and I appreciate the town attorney's graciousness and his time to work through that, and of course, allow the professionals to address any other open matters. We just want to bring this in for a landing so we're all very clear on what is required at this point.
All right, so you're in agreement that I will sign what will be a joint stipulated order that says that your client has submitted the correct application, whatever permit number it is, FDA permit number it is, and that in this case number, compliance will be determined once that permit number, FDA permit has been issued. Are you in agreement with that, Ms. Edwards-Walpole?
I'll have to speak to my client, but I believe that that's fair to allow us to continue to work on the mechanics.
Okay.
And by that, I simply mean what additional permits and whether it's the right-of-way permit, which we're waiting for feedback on. I think that's the only other remaining item.
Well, just so we're clear, the order won't speak directly to that. It'll just reference the FDA permit because that's all that's within my purview is the FDA permit under 175, 110.
Okay,
Is there an issue? Okay.
it's tough to say, yeah, I mean, I apologize, it's tough to say without the town's engineering consultant and their floodplain person. I look at, FDA separate, but a part of land development, so. I think Mr. Kurtz and I can work on clearly identifying any additional permits or steps that are needed, given where we are today.
So do you want me to prepare a joint order or are you two going to have discussions and you want to bring something back to me at the next hearing?
We'll bring something to you and may submit it jointly prior to.
Are you okay with that? I think that's what I'm hearing you say, Miss Edwards-Walpole, is that there's some other things that you want addressed. I'm happy to let you all do that, but for me to issue an order today, I need you both to agree on record as to what my order is going to say, because of the nature of this request. But if you want to work with Mr. Kurtz outside of this and bring back a joint stipulation to me at the next hearing, I'm totally happy to review and execute that then.
Sure, I think we would be best to continue the matter. We'll work on what that joint stipulation looks like. That will give us time to come back to you with something that is united and we've had a chance to review, and you continue to reserve your jurisdiction in this matter just on the issue of compliance alone.
All right, so I will draft and sign an order today that says that reiterates the compliance determination that I just made, and that also indicates that the parties will be working outside separately and will bring back to the magistrate a joint stipulation at a future hearing date. Are the parties amenable to that?
Yes.
Okay. All right, anything further, Miss Edwards-Walpole?
No, Madam Magistrate, thank you. That's all we have. I appreciate your time.
No problem. I'm sorry for the wait that you had to, and I'm sorry you got dumped there off the hearing. The power went out here for a second, so apologies for that.
Not a problem. Thank you very much.
All right, thank you, ma'am.
Okay.
All right, so that appears to be the last item on the agenda. Is that correct?
Fisherman, I wasn't here. I apologize. Did we approve the minutes? Because I skipped over that. I went straight to the case.
Going back to that,
Okay.
I skipped over that inadvertently. So yes, I did review the minutes listed on the agenda from August 4th, 2025, August 22nd, 2025, September 8th, 2025, and September 17th, 2025. And I will mark those as approved.
Thank you.
And then the hearing date, did you need confirmation from me? I have this on my schedule as January 1st, or excuse me, January 5th. So that should be fine.
Yes.
Unless you all tell me otherwise, I will be here. No, we will not be here then. No. All right, and with that, hearing nothing further, I'll adjourn this hearing at 12:29.
Thank you very much.
Thank you.
Thank you.